Let us pray. Eternal Father, we thank you for this opportunity once again to assemble together to do the will of your people. Father, we ask that right now that you guide us from above with wisdom and knowledge, that we'll do the things that are pleasing in thy sight first and foremost. Father, we pray a special blessing upon this county, upon this state, upon this great nation, that you would bless our soldiers, Lord, on the battlefield. Bless everything that's going on in this world. Father, we realize it's our author and finisher of all things. And we realize, Lord, that all things are of you, from you, and depend on you. And all things work for the good of you. Father, we pray your blessings upon this meeting as we gather here, that you will bless us with whatever you would have us to say or do, and let the will of the people be done. Father, we just pray your blessings, that you would continue to guide us and direct us in all things. We ask these blessings in Jesus' name, and for his sake we pray. Amen.
United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, good to see everyone here tonight. Let's go on to roll call. Okay. 18 present. Okay. Oh, Mr. Thacker? Okay. Oh, okay. Ken, are you going to fix that where you can vote, or she's going to bring you a battery? Okay. Once we're done, he's going to add him in. Well, I hope that's the only mistake for us tonight. We've already made one, and that'll take care of the rest of the meeting. Okay. Ken, will it let him do it now? Okay. Mr. Thacker, he said it wouldn't let you do it now, so we'll have to try it on the next one. He's going to count you in. You're present. All right. Next item of business is to approve the agenda. But before we do approve the agenda, we've got to add one resolution, 2012-35 resolution to amend Coffee County zoning resolution number 2006-39 to allow for gated subdivisions or private road subdivisions. And we just had the hearing on this prior to this, and we left off the resolution in the packet. So that's one item we need to add to the agenda. And like I said, the public hearing's already been held tonight. Any other? Commissioner Ricken?
Mr. Chairman, under 8, Section 8, I would like to insert and kind of push down the others. So have another 8A and everyone else go down B, C, D, and E.
Okay.
To put in nomination gentleman to fill the District 20th seat.
Okay. Nomination to fill 20th seat. Okay. Commissioner?
I make a motion to bring back the two resolutions that we held back 5 months ago. 2012 was 11 and 12, I believe.
Okay.
Bring them back to the floor with the agreement with the seconder of the resolutions.
Okay.
Ms. Fan.
10 and 11?
10 and
is that what
11,
you're
I'm
talking about,
sorry.
Commissioner? Okay, and that is the resolution to amend the provision of Article 4, Section 4-47? Is that the
For
one?
the planning commission?
Yes,
Right, and the
Okay.
one's reclamation, and the other one was zoning.
Yes, okay.
Mr. Mayor,
Yes.
if I'm, my,
Turn your mic on, please.
it is. The question was posed to me whether or not there need to be another public hearing on this matter. There was a public hearing a few months ago prior to the other meeting, and in the last meeting of the commission where we discussed this, it was referred back to the planning commission, for the planning commission to make some recommendations and further study before the commission took action. That has now occurred, and there's a report back, but the public would not generally be aware of the contents of that report, I guess, until now, and I assume they'll get it in this hearing, or the copies of it will be made available. I looked at the statute, and I think you might technically could go either way, but my view, the safe view and the appropriate view, is to make sure the public is fully heard on the matter and fully apprised, and for that reason, it's my recommendation, although we may discuss it to the fullest length, we should not vote on that until we have another public hearing, a hearing in which the public has knowledge of the report of the commission. So that's the advice I gave, and that's the advice I still present to you.
Yes, sir, I understand what you're saying, and you and I have discussed this once before. And if those two are not changed tonight, we've already had a public hearing on both of them, and they stand as being able to vote on them. The two proposals, whatever that came back tonight from the planning commission, if they change either one of those, you're correct, we need to have another hearing. If it doesn't make any difference, doesn't change anything in those resolutions, then we should vote on it.
The reason I think that still would apply, Commissioner, is that this body asked for input from the planning commission. And if this commission is going to consider input, whatever that input is, from the planning commission, then it's only fair that the public, who's going to be affected by this, be able to have a hearing after they have knowledge of what that input is, so they can include anything in that report from the commission in their comments or address those to the commission. So I really still think it needs to be the other way, that we delay the vote. I don't see there is any harm done by a delayed vote until we can have a public hearing. On the other hand, if we fail to have a public hearing and a court should determine we should have it, we throw out everything we did. If we wait and have a public hearing, have it promptly, have a public hearing on it, there's no harm done by doing it. So it's still my recommendation, and y'all have the right to vote and override my recommendation, but that's my recommendation.
I agree with you. The public has a right to hear the resolution that they came up with, the two answers to the questions. But if we, the body, do not accept those, then those resolutions still stand and should be voted on. I don't see any harm in bringing them back to the floor. If we change them, then we'll have a public hearing on them. If not, then we need to vote on them.
Okay. With that, I'm going to put those...
Mr. Chairman, would this not go under unfinished business?
Well, that's what I was just going to say. What I was going to do is to put it under the other resolutions, so we can take care of all the other business, and then we'll get down to those two at the end. I talked to the parliamentarian, and we can put it under unfinished business or resolution. And I'd like to put it under resolutions and put it under, it would be K and L, because we already got one for the other.
In J would be fine with other.
Okay, well, thank you. If that's all right with everybody else, I'll entertain a motion to approve the agenda as is. Yes, they're included under K and L. We'll have to add them under the resolutions, Mr. West.
Well, there's already a K and L. That's not...
Well,
change those.
no, I'm talking about under resolutions, under,
Oh, under, okay.
yes,
Yeah, under
we're going to
J.
put them there, We're gonna go through the rest of the business and then, because it's gonna be probably a long discussion.
Is that all right, Ms. Van?
Okay, with that, I'll accept a motion to approve the agenda as the changes are.
So moved.
Second. Any more discussion?
Mr. Chairman, you're voting on the agenda with these two resolutions being brought back to be added to this agenda at the objection of our county attorney. Our county attorney has advised this commission not to add these two items to this agenda.
Well-
That he feels it's in violation of giving the public and the many people impacted by this the opportunity to a public hearing.
Yeah, well, I think what the attorney said was, he don't mind adding it to the agenda, but not to vote on it. Is that right?
Yeah, it's all right to discuss it and weigh out what the commission did and decide where to go from there as far as recommendation, but I advise against voting on it.
Okay. So we're adding it with those, with what the attorney said.
We're adding it as discussion and not to vote on it?
No. We're gonna add it, you as a commission can vote on it.
You can vote, you can override my recommendation.
That's what,
But my recommendation is the commission
Yes.
not vote on it and allow the public hearing to be.
Okay, I'm not gonna override your recommendation. I'm just saying that if they're not changed at all, then we've already had our hearing on it because they stand as they were approved 5 months ago.
I don't know that they were approved 5 months ago. They were sent
Well, I mean,
back for
as they-
input from the commission.
As the hearing was held, and the motions were brought up, and so they were, approved as real motions, real resolutions.
Bob, can I ask a question on that
Sure.
too? In your recommendation, you said to have what'd you say, a quick public hearing?
Or whenever y'all want to schedule it.
Okay.
Public hearing on it, you got to give 15 days notice on it under our rules and under our zoning and under the statute. You could call a special meeting if the commission was mind to do so to address that.
That was my question, we can come out of this with that as the recommendation at the end of the thing?
Very well could, yes. Particularly in light of the fact that we don't have another meeting until
January.
January.
Any more discussion?
Mr. Chairman, these resolutions, they were discussed and debated, and then the Planning Commission was asked to look into this matter and address the two issues, which they did, and are bringing forth the recommendation. And we're not even taking time to consider that or give these people an opportunity to respond to this. This is totally irresponsible.
By placing those at the end of the docket, they have plenty of time we're going to hear what the.
You're trying to avoid giving these
I believe
people
I'm
out
talking
here,
right
all
now.
these families and the public,
Brian, I believe I'm
a
talking
chance
right
for
now.
a public hearing.
Go ahead.
We've already had the public hearing on them. We're going to hear what the Planning Commission came up with and their recommendation. It's just a recommendation. We, the body, are the ones that accept or decline those recommendations. So let's have it there. If they have good recommendations and we vote to consider those, then okay, we've changed those resolutions. Then they need to have a public hearing, yes. If not, we'll vote on them if there's no change.
Any more discussion? Let's vote on the agenda. Okay, let's have the count. Okay. All right. Has everyone had a chance to look at the previous minutes? If so, I'll entertain a motion to approve.
So moved.
All right, thank you. Second? All right. Any discussion? Let's vote, please. Who made the motion? Yes, we got you. We just didn't get... All right. Let's have the count. Did you mean to do that, Commissioner? So do you want a yes? Okay, we need to record him as a yes instead of a abstain. Is your battery not working? Got another battery here. Modern technology.
It's the end of the year, all our batteries are weaker.
Is that it? Their attorney says at the end of the year, all of our batteries are getting weaker, so. Okay, let's give the commissioner a minute to change his battery. You good? Okay, Miss Patton, I believe it's time for you. The other Miss Patton, I believe it's time for you to go to work here.
Number 8, election. Number 7, resolutions of memorial, sympathy, and commendation. I don't have any.
Okay.
Number 8, elections, appointments, confirmations. So we have the addition, District 20 seat.
Yes?
Yeah, I'd like to make a motion for the adoption for this body to appoint and elect and get sworn in tonight Gary Kidd, who is the winner of the election in District 20. And he can serve until the next general election since he was elected and won the seat to serve to the next general election. So the District 20 body has, citizens have been unrepresented almost for 4 months. We don't meet till January. We need to get him sworn in. He needs to represent this district tonight. So,
Is that a form of a motion, Commissioner?
yes, sir.
Okay. Oh, nomination? Okay.
A second.
So what about discussion?
That's a nomination. You can ask another nomination.
Okay. Is there any other nominations? If not, let's vote.
Mr. Chairman, could you clarify, has this been certified by the County
The-
Voting Commission?
The election
Yes.
has not been certified. Oh, well. But I mean, his question is though, has it been certified? Okay. Okay.
On this issue, I didn't have this presented to me until about 10 minutes ago. So I haven't looked it up, but I'll be happy to look up something on it during the meeting. My recollection from looking at something similar earlier is that he could be sworn in, but he can't perform official functions until he is certified. I think that's the status.
You're wrong.
Bob, I don't believe that to be true because we've had Miss Fan who was appointed and brought in until she ran to the election, and we've had that with several other commissioners. I don't see why there's any difference, except this one's taken place after the election, and it's the person who has a wide margin that's going to be certified. So we can make an appointment of him. We have the authority to do that as a commission. Then he'll be sworn in after that as in his elected position after it's certified. It's just a continuation of the same person. I can't believe we can't do that.
I don't think we have authority to make an appointment unless there's a vacancy.
Point of order, I think we've got a vote hanging right now on this. There's no need to discuss
Here's
it.
what CTAS says. Okay.
And that makes a difference how?
All right. What I did, I just give the attorney who's been out of town all day, I give him a copy of what CTAS said, so. And, in all fairness to him, he's been, like I said, out of town, so he ain't had the opportunity to share this with him.
Mr. Chairman, do we need to clear the votes and do it over again?
Well, I can read it to the commission under Tennessee Code annotated 51-104B1. Vacancies in the county offices required by the Constitution of Tennessee or by any statutory provision will be filled by the people, shall be filled by the county legislative body, and any person so appointed shall serve until a successor is elected at the next general election, as defined in Section 21104 in the county, and is qualified, provided that the candidate must have sufficient time to qualify for the office, as provided in Section 214106. Now, as I said, he's going to be certified. We can appoint him, and he'll serve to the next general election because he won to the next general election. This is purely common sense to have someone that's been elected to sit and represent their district. And any other issue just seems to be trying to thwart what is reasonable common sense.
Commissioner Bricken, my job is not to instruct you on common sense, but to tell you what I think the law is. I make mistakes on it sometimes, but my job is to protect the county. And I think the statute says he cannot perform official functions until he's certified.
Bob, in this case, we are appointing a person to serve until the elected official takes his office. That is purely within the statute. Has nothing to do with this person coming in serving as being certified for election. That will take place after this Thursday. So we would be appointing the person as a county commission. We have authority to do that under Tennessee statute. It has nothing to do with the election. It has to do with making an appointment now so that that group is being represented. Mr. Bryant objected last time when we were looking to make an appointment because he said the election was only a few weeks away and we've held an election. There's no reason to carry this any further. We would have brought this forward regardless of who the person was winning that seat. And it's more than common sense. It's purely within the power of this commission to do it. Or we need to step aside and say from now on we're never ever going to make an appointment to fill any seat in this group.
I'll remind the commission that we had one candidate was sworn in 3 times one night.
Say again?
We had one commissioner, or potential commissioner, was sworn in 3 times one night because we couldn't get over this hurdle. Let's get that stuff out of the way and move on.
Mr. Mayor, you said something earlier about when you gave the paper to our attorney that you had talked to CTAS today. Well, in your opinion, what did CTAS say?
Well, Bob's got the letter.
I'm looking at it and I
What
don't-
was the question that was asked of Mr. Baird? Did you ask about putting someone in before they were certified, or did you ask, can we appoint someone to a vacant position? There's a big difference.
I don't think this actually addresses the situation.
I call the question.
All right, question's been called. Let's have a count. Are you voting? Have you already voted? All right, let's go. Let's vote. It says voting, so.
Mr. Chairman, by the way, Mr. Alford is on his way.
Yes. Yeah, he called it. All right, let's see, got everybody? Let's have the vote, please. Okay. We need to, what? Yes, we need to swear him in. Teresa, do you want to swear him in? Mr. Kidd, you'll be Commissioner Kidd here in just a few minutes. Huh?
He's walking forward as a civilian.
Well, can't you add him just like that, like when Bertha gets here? Come here, man. Ken. I want to talk to you. Yes, go ahead. Anyway at all? Okay, we'll just have to let him vote verbally. Huh? Yeah, okay. Well. Okay, now, when he takes his seat, it'll still say Chris Byrd, but we'll note it that Ken says we can't change the name, but we can bring him from, absent to present. So I'm talking about on the voting board, we'll know that it is Gary Kidd. But you can just go ahead and get it where you can vote, right? Okay. Okay. Let's give him a minute here so he can get instructed on how to operate it. Commissioner Kidd, are you good to go? Okay. Also, when you speak, you got to push the button on your mic. Okay. Thank you. All right. Now, Miss Patton, the one up front here, are you ready to go back to work? Okay.
Notaries. Doreen F. Barnes, Pamela Gilly Campbell, Carrie V. Cunningham, Teresa L. Dixon, Phyllis K. Dillingham, Blakely S. Drake, Irene T. DeBicky, Rhonda Dykus, Barbara Ernst, Alyssa Fletcher, Susan Haley, Pamela J. Hockersmith, Carla House, Russell Hedges, Holly Lawson, Eileen Levengood, Jessica Jean Lowe, Steve D. Lynn, John D. McCord, Deborah C. Musel, Janice F. Nichols, Charlotte O'Kelly, Thomas W. Rutledge, Ben Shimwell, Jennifer Sutherland, Stacy Marie Starr, Barbara J. Suits, Karen Swan, Stan Teal, Rita J. Wilkerson, Bernice O. Williamson, Belinda S. Johnson, Christine Manns, Kayla Sides, Joanne Stryker, and Janet Gallion.
Okay, I'll entertain a motion to accept that list.
So moved.
Do we have a second? Second, thank you. Any discussion? Let's vote, please. There we go. All right, let me see. Yes, let's have the count. I was just making sure that the new commissioner got to vote.
20.
Okay, 20. All right. All right, Miss Patton.
All right. Tennessee Duck River Development Agency Board.
Okay. On this board, it says, I'm going to read you just earlier this year, the Tennessee General Assembly enacted legislative changes regarding the organizational structure of the Tennessee Duck River Agency. So these changes require restructuring of the board. So what we're doing here, Bill Brown has still got 5.5 years left on the board, but now the governor chooses who the members are. So, and I as mayor named those appointees, and then you as a commission voted in. We send it on to the governor, and he picks. And the names that I'm going to give you, you'll have to confirm here, is Bill Brown, Alan Howard, and Terry Hirschman. And with that, I'll entertain a motion to approve this.
So moved.
And a second.
Second.
Thank you. Any discussion? Let's vote, please. Huh? Okay. Who made the motion? Who made the second? If you don't mind, raise your hand when you make them so that she can see. Yeah, I know. Okay, are we voting? All right. All right, let's have the count. 20 yes, okay.
All right, C, Industrial Board.
Okay, we're going to start with the rule.
Bill Comer.
Okay. Tullahoma
Marvin McKee.
and Manchester. Is there a Manchester one?
We didn't have that discussion last night. We didn't have a caucus meeting last night.
Oh, okay. Huh?
Who's there now representing Manchester?
That's what we're going to do. We're going to go get the, we're going to, yeah, well, so is Ted.
Who's on there for Manchester?
Who's the Manchester? Come to the podium, please. Who is the Manchester representative that we're voting on tonight? Okay. Elmer Morris. Commissioner? Huh?
We'll recommend Elmer.
I'll
that-
second that.
Okay. Okay, now we need a motion to accept this and a second. You made the motion to accept, you made the second. Okay. All right. Any discussion? Let's vote, please. You don't. All right, let's have the count, please. Yeah, Commissioner, did you mean to? Okay, you meant a yes? Okay.
Mr.
All right,
Chairman.
hold on just 1 minute, please. Gonna take just a few seconds here. She's got to deliver something to the jail committee chairman, who has also been busy today. Okay, I'm just going to do one quick thing under reports.
Well, before we leave elections appointments, Mr. Chairman, we've
Yes.
still got other.
Yes.
I just would like to, just for the record, be certain that I appoint Mr. Kidd to the 2 vacant committee seats that were left vacant in September.
We already said that in the last meeting, that whoever won the election would be on the committees. And it was law enforcement?
Fine, so for the record, that's.
Yes. And Miss Patton said it's covered from the last. Okay. All right. And I guess after the meeting we can verify the 2. Okay. Just a real quick. I just got this letter from let's see, from Doug Shelton, who is Rural Development. That's where we're running our loan through the jail project. He says, I just finished discussing with Barry Burgess. He does not see a problem with starting construction. He plans to get me this letter this afternoon. So that's where we are on jail construction. As we speak, he should already have the letter, so we'll probably get it tomorrow or Thursday. Okay.
That was the reports for county officials standing in special committees. I don't have anything else.
Okay. All right.
Unfinished business, the IT policies and procedures.
Did everyone have a chance to look at the what the IT committee presented? Did you?
I did. I did not see any of the changes we discussed last time and said that were going to be put in.
Okay. And I think this is a recommendation from the IT committee to leave it like it is. Vice Chairman of the IT Committee. Yes, would you come to the podium, please, and address this? Mhm. Yeah, that's what we call a podium here in Tennessee.
I'll give it your chair.
And you should have a mic.
I do.
Okay. Commissioner?
Well, one, I want to make sure this is what the IT committee wants to bring forward to this commission. Is that correct?
Yes, sir.
So
Do you have a copy of it?
No, sir.
Would you like, here, there's your copy.
So the IT committee believes it's reasonable for county employees to play games on the internet during their work hours and to compete against others with internet games in doing their job.
No, sir.
That's what the policy says. That's what I'm concerned about, is this policy is where it was before, and you have to excuse me, it was a pile of crap when we got it. It's a pile of crap when we got it back today. This kind of policy, which permits county employees to be out playing games, to be out on eBay, to be out on Home Shopping Network, while we're paying them with county money, is wrong. And if that's what this IT committee thinks, and if that's what you, Mr. Mayor, since you're the CEO of this joint, believe is right to do in this county, then we need to be making some
Well,
major
I think,
changes in this
do
county.
you want to address some of those reasons why? That, is it that you want
Some of
to?
the specific issues that came up for, like, take the police, for example, you know, there's times that they need to be able to be out on Facebook or wherever when they're
I understand
doing part of
that,
their
and there's
job.
ways to make an exception to this policy, and we discussed those on the last time. This says any department head can improve their people going out and playing games and doing those things, playing on Facebook, and that people can use the county resources to do their own personal stuff. No business around permits their people to do that.
The intent of it was that the department heads know what their employees are doing, so therefore if their employees out here on eBay, they're going to notice that they're not doing their job. It's going to be very obvious to them they're not doing what they're supposed to be doing. That's not the intent of this. The intent was to allow the department head to be able to determine whether their employee needed to be out on the internet doing.
Well, I'm going to tell you that a while back, when we borrowed some software from the state, and this is a couple of years ago, when I was on the IT committee, we did do a scan and saw what was going on and what the computers in this county were being used for. And I can tell you there was more people than I can count on two hands who spent 6 hours or more each day on eBay and Home Shopping Network. So I'm telling you, we're wasting a lot of county taxpayer money. And this policy carries that forward and says it's okay. I don't agree with that.
As I said, the intent was to allow the department heads to know what to be in charge of their employees, whether they should know whether they need to have access to Facebook or Twitter, or, you know, depends on their department. It's hard to sit here and say that every department's going to have the same rules when, again, the police is one example.
Did you guys consider any of the wording that we put in at the last time? We've done it twice now, and it's come back with no changes, with the same mess that we got before. Like I said, you know, this, I can't believe we would bring this forward and believe we're being responsible to the citizens of this county. This is awful. And I'm sorry to say you guys, in my mind, have done a very poor job. I would call it a lousy job.
Well, we can get a motion in a second and let the body decide whether or not to accept it or to vote it down and send it back.
Move to table it.
Second.
He said you can't make that motion because we don't have anything to table yet. We first have to get a motion in a second.
And I'd like to add something as well before we move that on forward.
is typically with any kind of policy, whenever you're writing a policy, you have, I guess what you call the penalties for violating the policy. And there are no penalties whatsoever in this internet use policy and procedures. There's no penalties for violating it, no recommendations for reprimand or anything like that. So I think that's something that needs to be added as well.
Yeah. I agree with that. And the other thing I would add, the last time we discussed it, we agreed and said this would come back through Legislative Committee, and it would come back through Personnel Policy Committee and to the Budget and Finance because of the financial implications. As far as I know, it's not seen any of those committees, and I doubt that it will.
Okay. Let's get a motion and a second, and then you can make your motion to table. All right, let's get a motion and a second.
I make a motion to disapprove it.
All right.
I make a motion to table it.
Okay, do we have a second on that?
I'll second the motion table.
Okay. Any discussion? Oh, no discussion, let's just vote.
What are we going to table the motion first? I mean,
Yeah, we're gonna table it
first.
and send it back to them. All right, let's have a count. Okay, so it's tabled. Okay. The parliamentarian said that cannot be brought back up until we get a motion to take it from the table, so we'll have to go work on it.
Yes, sir, and that has to be made by someone who voted in favor of the table, correct?
Okay, let's go to our next item. Let's give him a chance to get it typed in.
Next item is the Planning Commission report.
Okay, has everyone had a chance to read the Planning Commission report? And is there somebody from the Planning Commission here tonight to address the report?
Glenn Darden is here.
Oh. What'd you say, Commissioner?
Glenn Darden is
Okay.
here.
Yeah, okay. Well, is Mr. Darden here? Yeah, okay. You want to step up to the podium? And let's get a motion and a second on the report.
I so moved that the report be accepted.
Okay.
Second.
Second by Bobby. Okay, now we'll get into discussion. Has everyone had a chance to read the report?
Let me ask a question. Does this report actually, if we adopt it, does it actually get embedded in the zoning code, or is this just a report?
It's just as a report. It's not adopting it in the code. It's just accepting it as a report. That's the way I understood it.
Yeah, that's what I thought.
This is not changing the,
Well, it's suggestions, I think, by the report. Isn't this a...
Which issue are we looking at? The reclamation costs?
yeah, the first, are we making motions on this separately?
Well, you
or
got
together?
discussion to, we're discussing it now.
Well, we're discussing together or separately?
Well,
There's two different
yes.
things here.
Which report, Mr. Darden, would you like to discuss first?
Well, I guess we can start with the reclamation costs.
Okay, that's where we're going to start then.
Well, specifically in that, what is meant by the 5-year period? Is that saying that if somebody builds a $10 million operation on their own land, that in 5 years we can go back in there and tell them, no, they can't have a license and they have to cease operation?
That is already in the county zoning resolution, this 5-year provision.
Okay, this is just...
It is already in there? When was that approved? Why are you putting it back in this report then if it's already been approved?
What do you mean approved? This is a report, a statement of what the planning commission felt about the issue.
Okay, this is not a recommendation to change that planning.
That's not a recommendation to change it, it's just a statement of fact. It's in the special provisions section.
Oh, I guess everybody's reading the report, is that?
In the current zoning, then, we have no controls over topsoil, is that correct? We have no controls over topsoil? So a guy can dig a 400-foot hole digging out topsoil, and he doesn't have to reclaim anything, and there's no problem with that, is that right?
I don't know whether there is topsoil.
That's
or
what
not.
your
It's
report
not-
says.
Words that say that, sorry.
I'll find the right words for you. Surface and subsurface coring of minerals excluding topsoil is permitted.
Yeah, that's what the zoning resolution says.
So we can dig up all the topsoil you want, dig a hole as deep as you want, and no one has to be responsible for ever fixing that again, right?
Well, like we're talking about now, this is just a report, and for you vote to accept the reports, that don't mean that what's in those reports are going to be changes made to the zoning book. This is their suggestions, is that right, Mr. Darden?
That's true.
Okay. This is just suggestions from the Plan Commission.
According to this, we don't believe we have the capability of making any long-term determinations as to what reclamation costs should be assessed or what kind of bonding should go, so that the 5-year period is what,
Yeah, I would think
what it's
not,
capped.
without the services of an engineer or someone to determine what those reclamation costs.
But beyond that, I
would be.
mean, we're only going to do it 5 years at a time. And if I read this, one way that I could interpret the report is that the recommendation of this report is basically every 5 years, the guy has to do the reclamation
Cost estimate again.
and get another cost estimate. But it could be interpreted so that he has to come in, tear everything out, reclaim it, and then come back, build it again, and start digging again.
Just to let the audience know, Glenn Darden here is the coach director. He's not on the Planning Commission, so there is other members. The Planning Commission is the one that drew up these recommendations, not Mr. Darden. So he's just representing. If somebody from the Planning Commission, the vice chairman or chairman's here, then they can step up here and answer some of these questions. Commissioner Duckett, you're on that.
This represents the position of the planning commission.
Do what, Commissioner?
This represents the position of the planning commission. This is what we recommend.
Okay. Ms. Willis?
It's not here.
She ain't answering roll call, Commissioner. Okay. Well, like Mr. Darden said, these are just recommendations. Any other questions on this?
I do.
Okay, go ahead.
Are there any industry standards or at least metrics by which these reclamation costs can be compared to maybe other quarries that have been commissioned in the past decade or so to get a better understanding of at least a starting point? Because you got to be able to set the bar somewhere in order to know where you're going. And
well, that's true, but you also got to have, and I use the analogy, you can't come in and sit down in front of my desk and ask me what it costs to build a house. I can't tell you. And I can't tell you what it costs to reclaim a hole in the ground. I don't know what size it's intended to be or anything else. Neither did any of the planning commission members. We don't have anyone available to determine that for us without going out and hiring an engineer after we've accepted their proposal.
So after the closeout of the mine, after it's been exhausted, the reclamation includes the actual mining hole itself and not just the operations around it, because I don't know of any mines in Tennessee where a 300 or 400 foot hole has been filled back in for reclaiming the land, unless it's there's strip mining, of course,
Yeah.
that deals with coal, and you're basically shifting a mountain range
I don't know
down
of
path.
any either, but in our zoning resolution, it does state that after reclaiming that quarry site, that it be replaced to the general topography of the mountain range. That's in the current zoning resolution.
Were you presented a reclamation plan from the right folks?
No. The only thing the planning commission had before it was the fact that in the zoning resolution now, it talks about a $95,000 per acre reclamation bond amount.
Did anybody check around and see what other states do? Like the state of California requires $5,000
It's what?
per acre.
How can you say it's $5,000 per acre when you don't know whether it's going to be 100 feet deep and 600 feet wide, or it's going to be 4 foot deep and 100 foot wide? How can you make that determination?
I don't think the hole itself is what they're talking about. They're talking about
No, it
removing the
is too.
structures and the concrete and replacing the land back like it was.
According to this zoning resolution, you have to put that land back in the condition that it was, the general topography of the mountain range. That don't mean leave a big hole there, the way I read it.
And the other two holes up there are just going to stand wide open?
We're not talking about the other two holes. They're grandfathered in.
Let me ask you another question on it then. In the bottom of this, you say you believe that the requirements of 1101 is that the growth planning and land use decisions made by the body should be consistent with the growth plan.
Right.
So we have another resolution coming up. You had a public hearing on. Do you have a report on how, and that's the one on the gated communities, how is it consistent with our growth plan?
It's consistent in that.
Do you have a report on it that says that?
I'm sorry?
Have we got a report from you that will show us why it's consistent?
You don't have a report from me because the current resolution allows for condominium development. And then you talk about the issue of whether or not we allow single-family residential property in gated communities. That, again, being presented to the Planning Commission, and they felt that should be have the same consideration as a condominium.
Any other questions on this one particular report?
Are we still just, are we talking about the zoning aspect of it as well?
The one that, is that the one you're talking about?
I'm sorry?
He asked...
Is it open for discussion, the zoning report, or are we still just on the reclamation? I had to step out for a moment.
Well, we're still on the reclamation. That's what I asked is to see if there's any more, any other questions. Any other questions?
Mr. Chairman, basically, as Mr. Darden's elaborating on, looks like to me the Planning Commission was asked to establish some common sense procedure in regard to determine the reclamation cost. And what they've done here, instead of coming up with some arbitrary number, as Mr. Darden said, there's no way you could determine what that is. One, you ain't got an application. You don't know what type of entity or operation it is. So the only way reasonably and logically to determine that is to bring in qualified people, an engineering firm that has the capability and expertise to do that, and establish a fair and reasonable reclamation fee for that particular type of entity and what they're going to do. Otherwise, You're just coming up with some nonsensical number, and you could have entities applying from one extreme to another.
And that's why I was asking what the actual reclamation procedure is. It's impossible. You can hire the best engineer in the world, but it's impossible if you don't know the metrics by which you're having to restore to. And that's what I'm trying to wrap my mind around is what are the actual metrics, what are the parameters that the site has got to be restored back to, where's that defined at, so that there could be an engineer who could possibly estimate the reclamation cost.
Yeah, it's defined in the zoning resolution, but as I've mentioned, it does say that the land be placed back into the general topography of that mountain range. What does that mean?
Now, that's in the zoning regulation now.
That's right.
Okay.
I take it to mean that you don't leave a 300-foot hole or whatever size it would be in the side of the mountain.
And I think what you're going to see, Mr. Chairman, too, is, which can be cited in numerous occasions in situations where bankruptcies and other situations can occur. If you don't have a bond, which is what protects the taxpayers of this county, then the taxpayers of this county could be caught with all those costs. And if the federal, state agencies said certain things had to be done, and there's no bond to protect this county, then the taxpayers are going to pay the bill.
Yeah, Bobby, we all understand that part of it, but at the same time, it's got to be a reasonable cost so the guys can operate a business reasonably as opposed to picking some arbitrary number. And I understand the process he's laying out. My concern when I read this is you build a building over there and you have an insurance agency and you're running it, or you're running your farm. I'm going to permit you to do that for 5 years. Then you're going to have to come back and ask me again, and then I'm going to establish that, oh, by the way, you're going to have to tear it all down, move out of it, reclaim it to where it was before, and then you can build it back and start over again. That's one way, the way these regulations are currently written, that you can read them and interpret them. And you can interpret them whereby you have to build the mountain back, or you can interpret it so that you have to be able to put it back where it's usable ground and you can plant the same kind of vegetation and those things. So it's a matter of interpretation on how some of this is going. And there's a big difference in how those costs are. That's what we're trying to understand and get some kind of a reasonable basis, as opposed to just saying you're not going to have any kind of business in the county because we're going to have unreasonable rules on it. And you know, we drive enough business out of this county today. I'd like to see some business come in and us actually get some development started back around here.
Now, I've got another question also. And I know we've got Ms. Warren here, an environmental attorney. But my understanding is that the state nor the federal government, EPA or TDEC, requires the full reclamation of a mining site in cases like this. So are we just, we don't want to pick an arbitrary number, of course, for a reclamation amount, but do we want to arbitrarily require reclamation if it's not required under state or federal law?
Did you hear the question, Mr. Darden?
I heard his comment, but the only thing I have to go by is the current zoning resolution, the statements in it.
Commissioner West, you're next, and Commissioner Duckett.
The current rules say that it's $95,000 per acre and times 190 acres. That is absolutely, there's no way you can get a bond on that. All Mr. Wright is asking is to make the playing field level so that he can qualify to come before the commission to ask for zoning change. That at one time was set at $3,000 an acre, not to exceed $95,000. Now, that might not be a good number. I think they're saying that may be 5,000, but you never gave a number at all. Well, how do other states come up with these numbers? They hire people to check and see. Did y'all check with the geologist or whoever it is you need to check with?
No, I haven't checked with the geologist.
Why not?
I tried to apply it to the current zoning resolution, and I don't think I have the funds and the monies to go out hiring engineers and geologists.
Well, I mean,
it's not.
That
it's
may be
definitely
true,
not
though.
in the zoning administration's budget. It may be in yours, but it's not in mine.
Well, address the fact that it
And I
was
don't
set at
know
$3,000 to, and not to exceed 95,000.
I can't.
And now it says it's $95,000 per acre. And you agreed at one time that was a misprint. We all, well, not all, but this body at one time voted to correct that, back to that point in 2006, I believe it was. And then they brought the whole book back before the commission to vote it in, though that change was not made to the book. So you're spinning your wheels. All he's asking for is a level playing field, just like everybody else, not asking for anything special, just to come up with something that he can reach out and get a hold of.
Yeah, the only thing I can do is look at the current zoning resolution. I don't have what things used to be or what they were X number of years ago. The one tool that I've got for running the office is the zoning resolution. That's it.
Yes, sir. And the first question that I asked you when I met you in that office was, is there anything in this book that's set in stone? You said, no, sir, it can all be changed.
No, it's not, and it is being changed. That's correct.
No, it's not. What? What's in stone?
It's
Okay.
not cast in stone. It is being changed, and I've used the illustrations before to you and many others that if you come in my office tomorrow to get a permit to build a swimming pool in this county, if I go by that zoning resolution, which I'm supposed to go by, I'm going to have to tell you, you got to go before the Board of Zoning Appeals and get permission to build a swimming pool. Okay?
I don't disagree with that. I'm just saying
That's the
and that's
reason
for
I'm
everybody.
telling you.
I may be right or wrong.
That it's not cast in stone. That needs to be changed. We all know that. The same issue has just came up recently with daycares within the county. A young lady called me asking about building a daycare in a specific zone district. I go to the zoning resolution, look, and I go back to the phone and I say, you can't have a daycare in that area. Well, I don't go on later on to the other zone districts and look and see what happened there, but I did have another person come in with the same similar question in a different zoned area. Looked it up. Lo and behold, you cannot have a daycare center in this county as a permitted use. It doesn't exist within the zoning resolution. That's another item that needs to be changed. Those are, I consider them housekeeping measures that whoever worked in assembling this resolution didn't have the resources or the time to look at each zoning resolution and make a matrix, if you will, and determine what we would do in reference to swimming pools in this district versus this district versus this district. It didn't happen.
Commissioner Duckett?
Yes, I'd like to point out that mining and quarrying are two different issues. Quarrying is not mining. So when you're talking about any reference to what it costs for mining is different than what it would cost for quarrying. The Planning Commission's approach to this was to recognize that each entity is different. Each application is different. And in order to get some kind of a cost for reclamation, we need to know what they propose to do and what it's going to cost to reclaim it if they were to walk off and leave it.
I guess I'm going to raise a question in this, and I go to Rush's common sense view of the world. I can't imagine why, after 5 years, you have to come back and ask Mother May I again. Why can't you simply update your bond, bring forth the information, provide an updated bond on wherever you are there, what's moving forward, as opposed to starting over again?
Well,
and you could make this a running timetable, and it'll be updated, and you'll get add-ons to bonds and amendments to bonds, but the guy can, whoever it is, can stay in business doing this kind of work in the common sense factor. This thing, the way it's written right now, says you gotta come back and reapply and get permission to do everything all over again, and by the way, we may not let you do it. And to me, that's just a turnoff to try to get people to come in and create jobs and do work.
Yeah.
That no one's gonna come in under those conditions, because they don't know who they're gonna have to pay money to the next time so they can get in and get a job.
Okay, and just to let the audience know, this is just a recommendation from the Plan Commission. This is not, you know.
Well, and that piece that you're discussing, again, that's in the present zoning resolution. That's not something that we're contrived to add to existing regulations. It's already there. I'm sorry? Yeah. But we're looking at two changes, as I see it right now, and not all these other issues that you might like to change as well.
If you ask any other questions. Yeah, Commissioner Bricken, but
Mr. Darden, you made a statement that I'm really trying to get educated, a little bothered. And you cited two examples, one the daycare and one the swimming pool. There, y'all, the zoning board meets monthly?
Pretty much monthly. The Planning Commission?
Yeah, I mean, these issues that you face in dealing with codes, enforcing reasonable codes and such, why aren't those recommendations coming to us to ratify or to change the code to reasonable codes dealing with daycare or swimming pools? I mean, in the last year, I can't think of any zoning request that has come out of the zoning board, and if you're being handicapped, if the citizens are being handicapped with unreasonable codes, I don't understand why they aren't getting changed.
Well, I guess that's a measure we'll need to.
Pardon?
I guess that's something we'll have to start doing, is bringing them to you
But
with a change.
But I mean, if you're telling your board that you're getting these requests, what are the boards just sitting on their hands and saying, tough?
Possibly so. They understand what I'm talking about, but we haven't gone further to make those changes. And I tell you what, if you took the current zoning resolution, you can consider adding a zoning administrator to the staff then, if that's what you are looking at doing. Because there's countless changes in there to be made.
I would hope the zoning board are made up of reasonable people that are listening to you, listening to the citizens, and then if there's a need to change some code provisions or hire staff, then they would be here tonight in every meeting. You know, we have budget amendments that come before us almost every meeting time we meet, and based on the fluidness of a zoning code, I could almost see that there would probably be zoning clarifications and issues that should be adopted by this commission almost every time we meet, rather than you being stymied with inefficient code that's not doing the citizens of this county any good.
Mr. Darden, you are working on some of that stuff to do a presentation right now as we speak, aren't you?
I worked with, for a number of months, back before I retired, with 2 or 3 members of the Planning Commission. We did it on a rather informal basis, and I have an Excel spreadsheet that I started putting together with all of the changes that we were wanting to address as far as permitted uses and conditional uses within the different zone districts in the county, along with these other things that Mr. Brickman just mentioned. But we started that, and it seemed to be a problem to get enough. I guess the point was I didn't want to come up with those on my own and present them to the Planning Commission and try to just push my changes through to the Planning Commission. That's the reason I wanted to involve some of those members on the front end before they went to the full Planning Commission, if you will. But that has fell by the wayside and will need to be continued.
Mr. Duckett, and then
But
you have a
Sorry.
question, and then Mr. West, you have a question? Did you raise your hand? Oh. Well, you're right, but go ahead, Commissioner Chance. As you know, as you've been here for 2 years, I usually don't read the board. I try to watch the front. Have you ever noticed that? Commissioner
I just want to
Chance.
ask how, this is, I know we're talking about reclamation costs right now, but eventually we're going to be talking about the M2 designation. The M2 designation, I'm trying to think about how it impacts things long term for future growth and things of that nature. Am I correct in assuming, or am I incorrect, because it's from my information, am I correct or incorrect in assuming that any activity in the future that is seeking the M2 designation would have these same 5-year requirements placed on? Because under the PC 1101, the nature and intent of it is to maintain a continuity in your zoning. So if we're adding these special conditions to something that's being requested as a M2 designation, does that mean that in the future anybody else who desires an M2 designation would have the same requirements set upon them as well?
as I understand, if it's a quarrying operation, it applies to the quarry. It won't apply to a CFC on Highway 55. That's not a quarrying operation. They don't have a reclamation cost there.
Okay. Commissioner Duckett and Commissioner West. Commissioner, just let you know. Commissioner Bricken, did you want to say something now? Okay, that's why I watched the front. Commissioner Duckett? That's okay. I watched the front anyway. Go ahead.
The reference to the 5 years, it means that we'll look at it again in 5 years. It doesn't mean they have to come back and reapply and all that. It just means that every 5 years we'll look at what's going on and if the reclamation costs are in order. If not, then we can adjust them. But it doesn't mean they have to come back and reapply after 5 years.
Okay. Commissioner West.
You said something about before you retired. Are you officially retired now?
No.
How many days a week do you work?
How many what?
How many days a week are you here?
5 days a week.
We called him out of retirement when the other gentleman got another job,
Okay.
and that he's working full-time
Okay, so
again.
you're back again.
He's back full-time
Okay.
now. He was retired for a
Well,
little
the
while.
question is your recommendations, you say, are what's in the book right now.
Yes.
What's in the book right now says $95,000 per acre.
No, that's not, we don't recommend that. I know that's in the
But it's
book.
in the book. That's
That's
all we're
right.
asking to change. That was all the change was. Set that back like it was in 2006,
Not-
or upgrade it a
Well, you
little bit.
question-
We asked you to do that, and y'all didn't do that. You come up with some other
You
recommendation.
question the $95,000. We're not gonna replace it with another invalid number.
But you haven't presented a motion to get rid of that number out of there.
No, and I wouldn't be able to without, I mean, you don't have 4 or 5 people in there going through the zoning resolution each day, recommending changes. Is that what we need? If it is, so be it.
I don't think there's I don't think that would happen. I mean, you're saying that you look in there, you see something wrong, then you bring it before the planning commission and they act on it. Is that what's happened? Does that happen every month at this?
No, it doesn't happen every month, no.
But you know there are areas, and you showed me a list one
Yeah,
time
I
of
do.
things that
I
are
do
really
know
wrong
there's
with
other
that, but
areas.
there's not been anything done about it.
And we have other issues that are on the planning commission agenda as well.
Mr. Chairman, you know, we've got 2 items for us here, reclamation cost and the M2 zoning recommendations from the Planning Commission. You got 2 Planning Commission members sitting over here. Mr. Duckett is one, Mr. Morris is another. And, you know, I've sat here and listened to Mr. West is personally sort of attacking, you know, Mr. Darden here, bringing up all these other issues in any zoning plan. There are lots of things. There are works in progress. Anybody that deals with zoning will tell you that. and there's things to be changed. This has become a personal attack on the planning commission. You got a lot of honorable people sitting out here on this planning commission, and they try to do their best, and they can't address all these things one time. They're just citizens serving on the committee trying to do the best they can and getting paid nothing to do it. And you know, instead of dealing with these two issues on their merits, it's turned into attacking Mr. Darden here, who this county is fortunate to have to try to keep these things working. And what we're asking to do, or what they were asked to do, is come up with a reclamation cost where it would apply, and to an industry it would apply to. Now, they did that, and I think it's very logical what to come up with, to look at each one individually, take engineers and people that are qualified to do that to determine an appropriate reclamation cost. Anybody just setting some arbitrary figure knows that's not reasonable. What they've got is a reasonable way to approach these. Yet we're not dealing with that. We're not dealing with the fact that M2s are zoned in this county already for NUGBs. We're not talking about, you know, the fact that nobody's been zoned out of this county. We're not talking about the fact that we have Public Chapter 1101 that says you cannot make a fundamental change. You're violating the law if you make a fundamental change in the growth plan. And that fundamental change would be to go create an M2 zone out here for a specific company. There's one company applying here. This M2 is being considered for the right company and organization, and they're asking to do this, and it's being considered for them. As far as I'm aware, they have not even made application yet. So your action that you're taking here in considerations is for one company and one entity. And you got a bunch of families represented out here. A bunch of them are sitting out here right now. They're going to be adversely affected if you go and violate the law, create an M2 zone out here for this company. Because then what you're going to open this county up to, anybody wants to come in here and do something, this is going to be a precedent. And they're going to say, you create this M2 zone for them, so whatever I want to do, if I want to put an arsenal in, if I want to put a hazardous waste incineration plant, any kind of operation they want to do, you created an M2 zone for this company to do this. So we can go anywhere in this rural area we want to now, and these people are going to come in the doors one after another and going to force this county to accept them and to create a zone for whatever you say want to, because you've created a precedent here. And you're going to open yourself up to a lot of legal ramifications, and you're going to expose this county to all kinds of detrimental impacts in the future. And when you do it, you got a bunch of families out here. We hear talking about one company here. How about all these families are sitting out here in this audience right now whose property are going to be detrimentally impacted? Where is the consideration for all these taxpayers, these Coffee County taxpayers and families out here? You know, this, you know, we're not considering them. And you're looking at things and wanting to criticize Mr. Darden, criticize these good, honorable planning commission members here. You know, they can't solve all these problems overnight. You got to work on them.
Overnight, they've had 9 years.
They haven't had 9 years. They've been working. Why don't you ask the planning commission members to stand and see who they are?
I know who they are, Mr. Brown. I'm not attacking anybody personally. It's
Sure
just an
sounds that
issue
way.
that has been pushed around and shoved off on the floor several times. And you know, I think you're attacking me now personally, and I don't appreciate that at all.
Ms. Patton, Commissioner Patton.
Yes. I think we're forgetting one little small detail. There's already a quarry right across the fence.
Okay, just to remind everybody, all we're trying to do tonight is, we got a motion and a second, just to accept the reports. That's all we're doing on this.
Yes, sir, I still have a question.
Right, okay, just as long as everybody understands what we're doing.
Mr. Duckett made a comment, and I guess I don't understand his comment compared, the words here say, any permit issued shall not be for a period exceeding 5 years. That doesn't sound to me like that's a continuation. That's an end. You're going to have to reapply for a new permit. There's nothing in there, in my interpretation of how you read that, and I defer to Bob, since he's the lawyer, and have to say, and then it says, after expiration date, such special permit, the board may review and grant an extension of time in the manner and procedures as prescribed for an original application. That says they're going to submit a new application. I don't know where Mr. Duckett gets his position, But what they've written in this report does not reflect that position at all.
Are we ready to go to the next
And
item?
well, and before I get off that, I've heard
Pardon?
from King Bobby over there. I'm not
Is that on the
representing
report? Yeah.
the people in this county. But the people in this county, if we don't get business in here, I'm going to tell you what, their property's not going to be worth very much either, because they won't have jobs and we won't be able to support them. And if we can't build roads, and if we can't build buildings, and if we can't bring in some kind of business as we keep running everybody out of town because of narrow-minded thought processes, it's about time we change this and get progressive and get some folks in here. And I don't mean Democratic progressive, I mean American progressive, where we're going to support business.
Are we ready to go to the next item on the report? Okay, Commissioner?
I
Back.
think, you know, Button,
Yeah.
okay, I think that $95,000 an acre is absolutely ridiculous. I think that to go back and look at the thing in 5 years is also ridiculous. You know, the other one is in out there, it's there for perpetual, forever, you know. And then to deny somebody else the right to do business is un-American. Furthermore, in that particular area up there, there are people who has property adjoining that favors it, that favors the new rock quarry. Those people are never mentioned. It's just the ones that are opposed to it. So in the interest of fairness, they should look at the people in the whole area, not just a few who are opposed to it.
Okay. Are we ready to go to the next item?
Please.
Okay.
M2 zoning,
Yes.
UGB designation. Would you like to read through that statement?
Mr. Darn, you can help me understand something in it. When I read this, tell me where, under our current county regulations, where could you put a quarry operation?
You can put it in the M2 location.
Where are M2 locations?
They're designated on the zoning map in urban growth boundaries.
They're all in urban growth boundaries. So according to our current planning regulations, in our infinite wisdom, we feel it's better to locate quarry operations inside urban growth boundaries, which are near higher residential areas, than out into rural areas with lower density populations. That's how it's written today. Is that correct? If there's something we need to change in this county, we need to decide what we just did by default. Bobby says we don't prohibit it. Well, we may not, but when you put, the only place you can put a quarry is inside high population areas, we're either stupid or we're very smart because we figured out a way that we can keep the kind of business out of town that everybody needs.
Commissioner Chance, do you have something you wanted to say?
Yeah, there's a couple questions I guess I'd like to ask is, currently, the property in question, it lies beyond the preferred growth area, correct? Okay. The reason why I ask that is because when I read state code, I'm trying to bring it back up real quick. It talks about the PC 1101 defined 3 specific areas for zoning. You have preferred growth areas, urban growth boundaries, and residential agricultural areas. Preferred growth areas can contain the urban growth boundary as well as rural agricultural areas, but beyond that preferred growth area, everything is a preferred, or is residential, or I'm sorry, rural agricultural. So where I'm going with that is when I read state code and try to wrap my mind around whether or not the zoning change can even occur, 6-58-112 A3 says that a county may establish separate zoning regulations within a planned growth area for territory within an urban growth boundary or within a rural area. It doesn't have an allowance for changing the zoning beyond the planned growth area, and that's one of the questions I've had. I'd like to have some clarification on. Not preferential to who it's clarified by, but some clarification on whether or not I'm reading this correctly. That says that outside of the preferred growth area, you cannot change it to anything else other than what it already is, which is rural agricultural. But within that preferred growth area, as long as it lies within a UGB, you can change it to M2.
That's
So anybody help me understand that?
What's the code section?
658-112.
Okay, and what did you say on it, Mr. Darden? What was your answer? I don't know if,
No, I thought he had made a statement that those UGBs were in.
and did you say that's the way you understood it?
Right.
Can I ask you something, Mr. Darden? LKQ.
Yes.
KQ is located on Hillsborough Highway, and it says in your recommendation that it is located in a Manchester UGB with a zoning of RS1, which is residential, but it should either be an M1 or an M2 zone. Does that not affect, with that business being in residential and being the way it is, does it not affect the tax rate that we would get as a county? Because if it was an M2 or whatever, would
No,
not
ma'am.
the tax rating be higher?
No, ma'am. The county tax assessor does not look at our zone districts in determining tax liability. You may have a anywhere else in the county, an RS1 location where there's a commercial building, it's still zoned RS1, but the tax assessor will tax it as a commercial use, if that's what the use of the business is. He doesn't go by our zoning districts at all.
Okay, is there any other questions while they're discussing? Any other questions for Mr. Darden? We're trying, Commissioner. Well, I think they're trying to discuss a TCA code. Is that what you're trying to find?
Mr. Chairman, after we're all said and done on this, is my understanding, we're being asked to accept the report.
That's all, sir.
That's the status quo. It's a Japanese yes. I heard what you said, but I don't agree with it. So we'll use that as a starting point to go to the next
Yes.
section of
Yes.
the resolutions. So
Okay.
whether we like it or not, we can
All right, so
still-
you're calling question?
I'm
we've
just-
already-
I'm just clarifying what the vote's going to be.
Mr. Chairman, does this adopt it, though?
Does it adopt?
Does it adopt it as part of the regulation?
No. No, it's just, I don't know if you might not have got here earlier, it's just a report and it's just suggestions, is all it is, Commissioner. All we're doing is gonna just accept the report, like any other report. It don't make any changes to the zoning by accepting it. Just the recommendations. Commissioner Duckett?
Yes, it's a report, but it reflects the feeling of the planning commission.
Yes, it does. It sure does that. But, yes, ma'am.
Well, I'm like Rush. It bothers me that the only thing that's come from the Planning Commission in the last year or 2 years that I can even think of is the fact about this. not any of the recommendations that you had said you wanted the planning committee to do. Somewhere along the line, like Rush said, we should be getting these to vote on if you wanted some changes.
Well, I think that what I'm hearing from Mr. Darden is that they're going to take his suggestion. Instead of doing them all at once, they're going to do a few at a time.
Mr. Chairman, point of information, it might be good if the planning and zoning boards did like a like a regular report out, on the agenda, with the agenda each month. And, if they don't have anything, I understand that, at least a quarterly report or something.
Okay.
So, that will give them the opportunity to share those types of things that they need to bring before.
And you're making that as a suggestion, Commissioner?
I'm making that as a motion.
Well, we got a motion and a second right now we're working on.
As soon as that one gets finished, I'll enter that one, please.
Okay, are we ready to go ahead and vote on, all we're doing is voting on to accept this report is all we're trying to do. We ready to vote? Let's vote on this. All right, let's have the count, please. Hold on just a second. Okay. Thank you, Glenn. Ms. Patton? Are we ready? Had to wake you up there, didn't I? Well, let's give him a chance to get the next. We're into new business. Is that right, Ms. Patton?
Yes.
Are you okay?
Business A, Resolution 2012-28, full commission meeting dates for 2013.
Okay, we have a motion to approve. Who made the motion? Thank you. How about a second?
Second.
Okay. Did you get the second there? Okay. Any discussion?
What committee did this come from?
Legislative.
Any other discussion? Let's vote, please. All right, let's have the count. All right.
B, Resolution 2012-29, resolution authorizing the issuance of general obligation bond anticipation notes in the aggregate principal amount of not to exceed $20 million in Coffee County, Tennessee, making provisions for the issuance, sale, and payment of said notes, establishing the terms thereof and the disposition of proceeds therefrom, and providing for the levy of taxes for the payment of principal of premium, if any, and interest on the notes.
Okay, let's get a motion and a second, and we'll start the discussion.
Can I ask a question? Is it possible that we could discuss both of these together since they relate to each other?
Yes. Yeah, we can. Matter of fact, Mr. Overman's back there. So let's do the other one too. We can just do them both.
Resolution 2012-30, a resolution authorizing the issuance of one or more general obligation bonds in an aggregate par amount not to exceed $22 million of the Coffee County, Tennessee, to finance a correctional facility, making provisions for the issuance and sale of said bonds and the levy of taxes under certain conditions, and authorizing the issuance of bond anticipation notes.
Okay, got a motion? Thank you. How about a second? Thank you. Now we'll get into the discussion, and Mr. Overman, would you come to the podium, please? Tim. Tim. Mr. Overman is our financial advisor. Okay. Commissioners? Any questions for Mr. Overman? Report, Commissioner Bricken.
Well, I'm going to just get CL warmed up. The two resolutions, first of all, the 29 and 30, think of 29 being like the construction notes if you're building a house as construction financing, and 30 being the permanent financing once your house is built. And that's what these two motions or two resolutions accomplish. We're committed to a jail, sadly. I mean, more sadly where it's going to be built, not that we don't need a jail. But that's my personal statement that I'll continue to make. But we got to go forward with it, and so we're here tonight. We need to cut ground. We need to move on.
Okay. Any other questions?
Mr. Mayor, if I could make a point, the two
Yes.
resolutions do need to be considered and voted on separately. The first one is the interim financing, as Mr.
Okay.
Bricken said, 29, the
Okay.
second one.
We can do that because we can discuss them both and then we can vote on them separate. All right. Any other questions to him?
I'll ask one to Commissioner Bricken. Where's the money to pay for it?
So, I have to go back to the money to pay for it is a little bit set aside once we pay off the Tullahoma lawsuit funds. The rest of it is pretty much coming out of new tax increases. So we got some dollars set aside, and see, again, good question, Eric. I'm just not as prepared as I should.
What I'm trying to fully understand. Is I know that a portion of it is going to be coming from once we pay off Tullahoma. By the time it starts coming due, where are we going to stand with having Tullahoma paid off to make sure that money's available to actually pay for it, to try to avoid a future tax increase? Because if that money's not there, then of course we got to vote in a tax increase.
And we have other obligations falling off, that there's going to be pennies coming out of other falling off bond obligations too. So the combination of those two, now when the permanent financing comes in place, I certainly cannot say tonight that there will not be some tax increase that this county will be facing because of the jail. But we do have a good amount of it with the falling off of existing bond payments and the Tullahoma debt. Ms. Hill, can you cite me better?
Sure, Mr. Chairman. Commissioner, long story short, I'm C.L. Overman with Cumberland Securities. Karen Neal, raise your hand. Karen is here from Bass, Berry & Sims. She's your bond counsel. Basically, long story short, the Coffee County Commission, Budget and Finance Committee, and staff over the years have been very intelligent in handling general obligation debt. I have all the numbers you may want to look at that I can hand out, but long story short, what Rush is saying is that long term, Coffee County's in good shape, because I know I should have this up on a screen, but your general obligation debt is very short. It's paid off. Current general obligation debt is paid off by 2021. That's where you want to be. It stair steps down. Now, obviously, the jail is a huge challenge for the county, but because of a lot of work from the staff and the commission and budget and finance, you've been able to secure USDA long-term financing, and that's basically what that red is. But what you see there, and again, I have these that I'll hand out if you want to look at it in detail. Once the county gets through the front end years, which you can do given fund balance, and Mary Ann, give me some help here. we've gone through this time and time again. Once you get through the first 3 years, the first few years, your debt service basically goes back to where it is right now. So in other words, you're using very intelligently something called debt capacity. And that debt capacity is, you're basically paying this right now. Yeah, it's going to be a little lumpy here in the first few years, but you've been very fortunate in terms of building fund balance, and you made good conservative decisions. So long term, your general obligation debt looks like that. In other words, you sort of pick up where you are right now. So maybe that goes to answer the question. Yes, funds have been allocated through pennies on the tax rate, other sources. From an outside perspective, we agree with the county approach that long term you'll be fine. In the short term, it will take some fund balance which you have available to get you through these first few years. Did I even come close to answering?
Most definitely, and I guess I was trying to get an understanding of how many pennies on the dollar are we talking, if there's an estimate or anything like that.
Eric, right now there's 7 cents in the general debt service, which is Fund 151, is to pay for the bond, the jail bonds. Also, the $250,000 litigation tax that was increased about 3 years ago, that's also designated to pay for the bonds.
That was both those were added in 2010, correct?
Yes.
August 2010.
Yes.
Okay.
Now, when the Tullahoma lawsuit is paid, and we have about 4 more years on that, there's 4 cents that will be moved out of the general fund over to general debt service, and that's the 11 cents you've probably heard us talking about all these years. So that'll be the total of $1.2 million is to pay for the jail bonds annually. And we still have $2.1 million in fund balance in the debt service to use.
Thanks. Commissioner?
And I want to commend CL for the work he done on that of taking care of the debt capacity. And that, along with building the schools and those issues, it still does leave us short on the renovation of the elementary schools. So that's still hanging over. So it does not address that. But the jail has been mandated by the state that either we build it or they build it, and it's much more economical for us to build it.
Okay. Commissioner Meyer.
You mentioned in oncoming years the debt load of lessen on us. My question is, the first few years of struggle, can we pay for it without raising taxes?
You heard the question?
I think, Mariana, and you can help me there again, our look at it says you can do that with fund balance.
Yeah, we can. To answer your question,
To
yes,
answer your
we can do
question,
it.
yes.
And that's with the expectation that there's no surprises or anything like that in the next couple of years with potential lawsuits, depending on how the votes come out tonight for this the zoning issue or anything like that, because I guess it's not factoring any of that in, is it?
Well, no, I agree with Eric there, but guys, don't get me wrong. This gets the brick and mortar of a jail built. It doesn't cover all the occupancy and operating costs of a new jail. And that will be a big, big budget issue. But as far as the bond costs, as far as the pennies for the brick and mortar, for the most part, those pennies are there. We shouldn't face any impact unless we certainly hit a major cost overrun on the construction. But the $20 million, the plans, the contractor says we can get it built that way. But let's don't go to sleep tonight thinking we'll be able to walk in and that jail will be occupied without a lot of additional dollars.
Let me explain the difference on the 2 resolutions between the 20 and the 22. This commission earlier, Mariana, about a year and a half ago, issued a $2 million note to help start with jail expenses. Well, as a result, we're only suggesting you issue $20 million in interim financing over the next couple of years. And then the 22, of course, is the USDA loan, which nobody likes to borrow money personally or organizationally. On the other hand, your interest rate on this $22 million resolution USDA loan is 3.5%, which is historic. On the interim financing, it will not exceed 1% over a over a 2-year period. It'll be a fixed rate. There is, Rush, we had some good discussions. I'm sorry, Commissioner. I've known you too long. We did have some discussions, and we've modified the preliminary official statement and the resolutions to enable a bidder, this will be competitively bid on the interim financing, to enable a bidder, if they want to do a drawdown, to suggest that when they get the bid, and then that's something we can analyze and see which is the best way to go. But interim financing under 1%, again, that's because it's so short. I mean, we're talking about a 2-year set of notes for $20 million, and probably less than 1%, because you're probably going to get 10 to 12 bids from the whole national underwriting universe.
Okay, any other questions? If not, Commissioner Morris, if I could ask you, and Commissioner Duncan, since you seconded, since CL said that we need to vote on them separate, do you have any problem with doing that? Okay. Once Commissioner Alford gets back, then we'll vote on the first one, and then the second one, since Mr. Overman said he needs them separate.
Karen reminded me of that.
Okay. Waiting on Commissioner Alford to come back. Maybe we'll take a break. Yeah.
Mr. Chairman, in all due respect to our fellow commissioner, Mr. Alford, but for the sake of time, I would just like to go ahead and vote.
Well, we got to get his vote because he's here.
I mean, I'm no respect for him, but I mean, if he's here,
Sheriff,
he's here. I don't know how long we.
Can you go see if you can find Commissioner Alford? He went left. He went left, Sheriff.
Steve's had a tough enough day with that.
Commissioner Bricken, come here a minute. Come here. I need to talk to you. Hey, we don't have a timeout corner here, though. You okay?
He's come in.
There he is.
But we
Okay.
lost the chair.
Oh,
You know,
Commissioner Alford, we're going to vote on them separate because Mr. Overman said we needed to. So we're going to vote on the two resolutions separate. So right now we're voting on 2012-29. Let's vote, please. Well, that's okay. We got a couple of deputies that'll work for us. We'll send one of them after the sheriff. Commissioner Thacker, Commissioner Bryan, and Commissioner Meyer. All right, let's have a count. abstain, it looks like. Okay. All right, okay, we found him, Sheriff. We, okay, let's give him just a chance, and we're gonna do, Ms. Patton, what's her next?
Resolution 2012-30.
Okay. All right. Are we ready to vote? Are you ready? All right, let's vote, please. All right, let's have a count, please. Okay, 18 yes, 2 noes, 1 abstain. Okay. Ms. Patton?
Resolution 2012-31, resolution authorizing Coffee County to enter into a contract with the Tennessee Department of Transportation for assistance in constructing an industrial access highway for Omar Inc. project in Coffee County Joint Industrial Park.
Okay. At this time, before we get a motion in a second, you, when you came in as commissioners, you seen where there was a few words left out of the resolution 2012-31, and you should have that copy, and it should say, it's highlighted and it says an acceleration lane in 2 different places. So that's how the resolution is going to be voted on, and I'll entertain a motion to accept that in a second.
I move that be accepted.
Thank you. Thank you. Commissioner Duckett, second?
Second.
Okay. Tricia, did you get one of them seconds? Okay. Any discussion? Let's vote, please. Commissioner West? All right, let's have the count, please. 21 yes. Go ahead, Ms. Patton.
E, Revenue Tax Anticipation Note, Series 2012.
Okay. Entertain a motion and a second, then we'll discuss this.
So moved.
Thank you. How about a second? Thank you. Now, discussion? Commissioner?
We just have to have some cash, and this is a normal financing means for Mariana to raise cash until the big dollars roll in at the end of the year and by March. So this is just floats the county.
Okay. Any other discussion?
So I guess so I understand, this is, you said in March, so that's when basically all the property tax collections will be coming in and at the end of February, and
Right.
this is just meant to carry over until then. 'Cause I don't remember voting on something like this last year, but it's been a year and there's been a lot of resolutions, so.
It's a change in the state requirements now. Anytime we do interfund loans, we have to do this documentation and put it on the agenda.
Okay, thank you.
Okay. Any other discussion? Let's vote, please. All right, let's have the count, please. 21 yes. Okay. Ms. Patton?
F, Budget Amendments.
The first one is for general fund, number 101, 2013-1. It's an increase in revenues, decreases in fund balance, total of $208,658. An increase in expenditures, $208,658. This is a decrease in the unassigned fund balance of $43,000. which brings the unassigned fund balance to $814,752. Next one is for the highway fund. It's 131-2013-002. This is a transfer in from the Rural Capital Projects Fund of $26,000. Increase in unassigned fund balance of $26,000. $17,000 of this is to add because of the decline in the mineral severance tax in the highway fund, and the other $9,000 is to help fund the bridge fund. The last one is the capital projects fund, where we're transferring the $26,000. Decrease unassigned fund balance $26,000. Transfers out $26,000. That brings an estimated unassigned fund balance in capital projects of $116,173.
Move it be approved, Mr. Chairman.
Okay. Do we have a second? Thank you. Did you get it, Teresa? Okay. Yes, Any discussion?
I just got a question.
Okay.
Since it popped up in the budget stuff with the Homeland Security funding and those kind of things. Can someone give me a quick rundown over since 911? I know we've gotten a lot of funds for Homeland Security and those kind of things. Have we done anything with those to have emergency equipment such as generators and heavy equipment to move stuff so that we don't end up like in New York or those places when you have a problem and all we have is radios to talk to people about where the rocks are and the problems, and we can't do anything about them?
We've made a lot of purchases. We can get you a list of what's been purchased since then.
Well, Commissioner, what you can do after the meeting, the EMA director's here, and we have a Homeland Security, 13 counties, and he can fill you in on what this county's got. All counties, the whole deal is to be able to support all of us, you know.
No, I understand that, and that's what New York had, and they're sitting there on their hands because they don't have anything they need to fix it.
But Commissioner, I assure you that we have it, and you can talk to the EMA director after he'll be glad to take you back to his office and show you the plans and the funding.
Yeah,
Okay.
I'll do that, and I would like a general list. It doesn't have to be a line item, but I would like a list of what we've been
Just
doing.
to let you know also, Commissioner, I just got appointed chairman of that committee. It was my turn, so. All right, let's vote. Let's go ahead and vote on the budget amendments.
I was just going to ask, is it possible to vote on them separately?
Well,
or do they have to all be voted on?
Commissioner Bricken, you want
to? They can all be voted separately, and if there's a particular amendment that you would like to see voted separately, I think the prerogative of any commissioner to break it out.
And just to let you know, it all went through Budget and Finance too. It's all been approved by them.
Just for sake of time, I would like to see it approved altogether.
Yeah.
That's the will of the commission.
Let's vote, please. Ms. Thomas? Thank you. Let's have the count, please. Okay, Ms. Patton?
Okay. G and H, Mariana said that we probably should do those two together. Resolution 2012-32, a resolution to authorize an employer participating in the Tennessee Consolidated Retirement System as of June 30, 2012, to change from its existing regular defined benefit plan to either the alternate defined benefit plan or the hybrid plan in accordance to the Tennessee Code annotated Title 8, Chapter 35, Part 2. And H is Resolution 2012-33, State of Tennessee Deferred Compensation Plan to 401K Resolution and Participating Employer Agreement.
Okay, let's get a motion and a second, and then we'll have discussion.
So moved.
Thank you. Thank you, Commissioner Duckett, for the second. Now, discussion?
I just
I
got
have
one question in it. There are a couple of boxes where it says check box 1, 2, or 3, or check box 1 and 2, and nothing's checked, so I presume there's a reason we didn't check those.
Did you hear the question about the... Oh, okay, is there somebody from the state that can answer these questions?
Steve McCombs is here from the state.
Oh, okay.
In case there's questions.
Yeah, he was here early. He gets to his
Didn't know who he was.
he gets to his appointments early. I'll have to attest to that.
Well, yeah, I was looking around. Actually, I am not with the state. I'm with Great West Retirement
Excuse me,
Services.
I'm sorry, I knew that.
It's okay.
Did you hear the question?
I did not, please.
Ask him the question again,
I can
Commissioner.
actually answer Mr. Kelly's question. The reason why some of those boxes are not checked is because I've got to meet with the people from Great West and go through that application. The main thing tonight is checking whether we are going to move to a defined compensation plan, and then those other items will be checked according to what, Budget and Finance had voted on. The one thing we do have to decide tonight is if we do move to the defined compensation plan is how much are we going to match the employees? Because we didn't decide that at Budget and Finance.
And that's exactly what I was going to ask as well, is what the match is going to be. And
Right.
has there been any discussion or look at comparable matches for other municipalities?
The limited discussion on that particular match is 5% number. That's for most municipal, I shouldn't say, most large employers. I think in several, I know out at the base, 5% match is the acceptable match. I think, I'm not sure, most everyone here, if you're currently working, probably are under a defined contribution plan. I can personally say I'm one that has a 3% match. So it ranges from probably 2.5 to 5. 5% is considered a good employer match. It's budgetable. That's the main thing we're trying to accomplish here, is come up with, and again, this is long term. This is something, when I wanted to get this on the agenda, this is something that will only be able to allow the county to control their pension costs somewhere 20 and 30 years as new employees come on the plan. All existing employees are grandfathered. So it's a 20 to 30 year rollout process. And so that's what we're trying to accomplish here, is put the county's retirement plan on a good budgetable level that provides our employees with a good contribution that will allow them to build up a good retirement plan. And so my recommendation would be 5%.
Any other questions?
Russ, having looked over a lot of proposals over the years, that's a number you see a lot of, so that's not an unreasonable number, and I concur, and we have to do something long-term, and you have to protect those folks who you have agreements with currently so that they don't suffer unnecessarily for it. So doing this over time and people coming in knowing the rules going forward is an appropriate way of doing it.
Any other discussion, questions? If not, let's vote on the two resolutions.
Does that have the 5%
It's McComas. Not really. I represent, there's two different pieces of this kind of. There's TCRS, which I believe they were supposed to be here. I didn't see any of those out there. But and Great West Retirement Services. We handle, for the state of Tennessee, the defined contribution plan. So we would be the one with the employees would work with on that. No, other than that, no other statements from this. Mary Ann, do you have anything that you'd like me to point out or specifically?
Well, Great West, as Mr. McComas said, is the plan administrator that the state of Tennessee is contracted with. And I was pleased to say that they had a smaller basis point, that the employees will end up being charged than what we currently had, so.
Okay.
Can I clarify something to make sure when we vote?
We're in the voting process, but go ahead.
Well, in doing that, what I heard her say was these are not complete, the resolutions. That we are approving the concept, and there are some items that we need to work the final solution on so we get the right box checked. Because if we just vote this in as approved as it is, there are empty boxes that we then will not have a complete plan, if I understand this correctly.
And those will come back certainly within the appropriate timeline. I mean, again, the effective date of this is July 1 of next year for new hires after that date. So but we have to have a 6 months ahead of time to go ahead and say that that's where we're going to go with it. So the funding, I don't know how quickly, again, as soon as Budget and Finance meets, certainly we can come back to the commission, hopefully at the January meeting, and insert the boxes by then. Would be that?
Well, as far as Great West is concerned, you could start at January 1st, yes.
Yes.
That's perfectly fine.
Commissioner Alford.
And Mary Ann, or someone, whoever can answer it, whoever can best answer the question, the existing employees, is this going to cause any kind of
No, that will still be funded.
They stay under the current plan, but is there any differences in the law? And I guess this is where the county attorney would need to come in. Is there anything in there that would have a negative impact toward the county for having one set of employees on one program and another on a different program? Okay, and I'm thinking it's okay, but I'm not as familiar with the state statute.
I'm not either, but
Commissioner Bricken.
authorizing us to go to this, so
Yes.
There's a lot of precedent and recognition of the existing plan.
And I understand that, but I didn't know if other areas are rolling all of their employees under the same program, or if they have that option of and/or.
I'm satisfied plans can change and new employees come.
Just, I done voted, and I just want to make sure.
Well, let's go on and vote. Where some of us are already voted, and looks like the Manchester side's already locked in, so they already made their mind up. Well, that's
Well, Mr. Kelly, Section C doesn't apply because we're not electing that type of plan. And it's only Section B and
Section N.
resolution drafted or come out of the state. I assume, Steve, you've seen the standard resolution?
I have seen that, yeah.
Now, tonight, do we need to go ahead and make a completion of, under 32, those boxes tonight.
Well-
There is what would be a
I would say I thought I was under the understanding that you guys were first deciding whether or not you're opting out of the TCRS program. And then the second part of it would be whether if you're doing that, you're going to go to the defined contribution plan with Great West. So if you go with the defined contribution plan with Great West, that's what you would be voting on tonight. And as far as the boxes, it was on, what page was it again, Commissioner? That you were looking at? I didn't see. I should have them here. Okay. Well, there's two pieces of this. The first piece really is the Tennessee Consolidated Retirement System. This is where you're deciding on whether or not you're going to, I'm sorry, this first piece is actually, let's see. Oh, I'm sorry, it is for you're determining whether or not there's a match and what percentage match you're going to do. I think you've discussed the fact that there's a 5% match is kind of the way to go. So I guess initially you'll be voting on that. And I guess, right. Marianne, I believe they probably will need to have this checked in before they vote it. You see where we are on the document?
Oh, okay, yeah,
Then under B,
3, right. That's what I was saying, I didn't know what, they didn't decide what the match was going to be at the meeting. So I couldn't mark it. But yeah, there'd be 5%.
So do you vote on whether or not to approve the 5% and then vote accordingly after that?
Okay. Yeah, go ahead.
Well.
Okay, parliamentarian time.
Ladies and gentlemen, you've already voted except for one person. And so the motion, is going to pass or fail according to your vote. Now, if you want to adjust this motion, you will need to reconsider it. And when you vote to reconsider it, that puts it back on the floor. You can make whatever adjustments you want and then vote on it again.
Mr. Chairman, we could change our votes right now, couldn't we?
That's a...
when you say, But if you fail it, it's failed, or if you pass it, it's passed.
Oh, okay.
To change, to do anything to it, you've got to reconsider.
That's it, okay.
Okay, so we don't need a motion to reconsider.
Well, you got to finish voting first.
Yeah, okay. Okay, let's vote. Let's have it. Oh, wait. Yeah, let's have the count, please. Okay, now, Mr.
And to reconsider it, someone who voted on the winning side will have to make the motion to reconsider.
So moved.
Now second that.
All right. Any discussion?
I guess I would make a motion at this point that we
Okay,
amend.
first you got to pass the motion to reconsider.
Okay, any discussion? If not, let's vote, please. Is that okay if you can? Are you up there? Yes.
You voted on the motion
We have
to
a
reconsider.
motion and a second. And let's vote, please. To reconsider. Well, we got to make some changes.
In there because I didn't know what.
Well, okay. All right, 19 yes and 2 no. Okay, now what's the next step?
The motion is back on the floor.
Okay.
I'd like to put motion 2012-32 back on the floor, and on section B, mark box 3, and section C, mark box 1.
Okay.
Repeat those, Russ.
You're making that as a motion for the amendment. Now, do we need a second, because we're going to have to vote on it.
Second.
He's made that as an amendment to that resolution, and that needs to be second and voted on.
Okay. We got a second.
Repeat the section again, please.
Under section B, number 3, mark number 3, assume the 5% employee's contribution. And under section C, 1, not provide cost of living increases for retirement.
Yeah, after this amendment. Now, make sure everybody understands that all one thing.
Okay. Rush, that's all one amendment that you're doing right now. Okay. And you understand that? Who seconded it? This is all one amendment. That he's...
Yes, but I have one in there that I'm a little concerned about, and it's section D. I kind of feel like if we could find out what part-time is, what is our magic hour in the county? Is considered full-time, part-time?
Full-time.
Okay, I didn't see that I didn't see it on down there. I didn't see it on down there. I would like to consider that we include that. I mean, I think that many hours, those folks certainly need to have some sort of retirement benefit.
You'll have to vote on Rush first.
So since he's in the second, I was thinking he got a second.
Oh, did he second?
Yeah.
Me second.
What I'm...
Just a minute, just a second.
He second.
If Rush is agreeable with it.
Rush, did you hear what Commissioner Alford said?
Well, before we do that, again, this did have some discussion in budget and finance. Long-term part-time employees is an anomaly here at the county. We just don't have any long-term part-time employees. In fact, I'm not sure if we have very many part-time, but most part-time employees move, if they stay with the county, will end up going into a full-time position. And therefore, the administrative cost of part-time people coming in and out of the plan just because of the nature of part-time just I think would make it prohibitive. I mean, again,
Look at it in a different perspective. As you add those part-times in, it helps to decrease the amount of overtime that you're paying full-time employees that you can implement. And that's kind of the angle that I look at. It's another benefit that you can entice part-timers to want to hire into Coffee County.
Well, again, Virgil, based on my personal experience, the part-time people I hire, the last thing they are thinking about are retirement benefits. It doesn't make their decision to come to work. Again, they come to work part-time, they either like it and either look for a full-time position within the county or the employer, or they know they're temporary part-time and going to be going on to college or doing something else. It's just the nature of part-time employment.
And Commissioner, if I might add, it's in the state plan, the deferred compensation plan in the state, part-time employees are eligible to contribute on their own, but not get the matching contribution. So if they wish to be part of the plan and contribute themselves, yes, but they don't get the matching contribution.
But they could do the same thing with an IRA.
Sure.
Commissioner Kidd?
My wife just took a job with Tricor,
right,
the Department of Corrections, and she's a part-time employee. She won't get 30 hours a week, but they are making deposits in the state's defined benefit plan for her.
Not the defined benefit plan. I'm talking the defined contribution plan.
Right. I mean, she will get the state retirement as a part-time employee. She will never be a full-time employee.
Right, but we're not talking about the defined benefit plan for this situation. We're talking about whether the county is going to enact the defined contribution plan, which is a little bit separate. So your wife could participate in the 401k plan, as contributing her own dollars, but no state matching contribution.
Commissioner Bricken, since you made the motion, you'll have to agree to do that, or we'll have to vote on your three recommendations, and then we'll have to let him do.
Well, I'm
but
just
if you
more or less
accept
asking,
his,
just more or less asking as a friendly amendment. But
do you accept his or?
Can Commissioners, would you like me to see amended to add it? If you're not, then why? I mean, just a quick show of hands, or if I don't see the hands, I'd rather leave it as it's marked.
Well, you can leave it like you did anyway. We can vote on yours, and then he can get his own amendment if he...
I'm good either way. I just look at it in the perspective of part-times. It gives them some stability and gives them some desire to be part of the county. So,
Commissioner Bricken, do you want to leave yours? Okay, let's vote on the way Commissioner Bricken is then. No, we already got it. All right, let's have the count, please. 21 yes. Okay. Commissioner Alford, okay. Ms. Patton.
Aye. Resolution 2012-34.
Wait a minute. We're not done.
Okay, well, hold on.
All that we've done.
Oh, what? We got to vote on
Yeah, all we have done is passed Mr. Brigman's amendment.
Okay, so now we got to vote on this
So
resolution.
that amended the resolution. So now, as a body, you've got to vote on the resolutions as amended.
Okay.
Make a motion that we pass that amendment, that resolution.
All right, thank you. How about a second? Thank you. Any discussion?
Yes, are there any other blanks that we need to fill in before we do this and go back again?
All right, let's vote, please. Okay, let's have the count. 21 yes? Okay. All right.
Aye. Resolution 2012-34. A resolution authorizing Mayor Pennington to sign the TVA easement.
Yeah, did we not, what about 2033?
Did we?
Thought we did those together.
We done both of them together, Rush. Well, I thought we did.
That was my understanding.
I read them together.
Yeah.
Then I'm going to make a motion to bring 33 back to the floor because it's got blanks in it and it's not complete.
Huh? Do what? Okay. Okay, she is saying that we only did 32. And she's the record keeper, so we're going to go with that. Okay, Roxanne?
Okay. 33.
Yeah, read it again.
State of Tennessee Deferred Compensation Plan to 401k resolution and participating employer agreement.
Okay, we're going to need a motion in a second. Motion to reconsider it. Motion to reconsider it, Rush.
Oh,
That's what,
honestly, I thought we were just voting on 32 before, so.
hold on a minute, let's, yeah, not 33.
Mr. Brigman made the amendment, and that, your amendment, Mr. Brigman, just dealt with 32. Okay,
Just adopted 32 as amended.
okay.
And I made the motion to pass 32.
Okay, then.
Oh,
then-
yeah.
I was assuming it was 32 on.
All right, now,
That's fine. Very good. Ready for 33. Very good.
okay. Okay, we got a motion, we got a second. Who made the motion?
So moved.
Okay, and second? Okay, thank you. There you are.
Now,
All
before
right,
we
now let's get into discussion.
before we get to the vote, are there any
Yes.
of these blanks that we need to have
Yes.
checked before we move forward? It looks to me like on page 4, we need to do something with number D.
I think Mariana said let's go down.
While we have Mr. McComas here, we can explain what it means, and we can mark them as we go.
That's fine. I'll be glad to.
Okay. All right, who's gonna drive this conversation? Mariana, do you wanna go down it or? Rush, Mariana, one of you.
Marianne, the first place I saw is on page 4, but there may be something I missed in the front part.
I don't see anything on page 4. Mine's marked.
It's,
What's it marked as,
Okay,
please?
D on page 4. That should be 18 years of
the
age.
box is not checked, though. It does say 18 in the blank, but the box is not checked.
Okay.
Okay.
I've checked it on mine, sorry.
All right.
Right. Page 5, automatic enrollment.
Well, automatic enrollment is a wonderful tool in the fact that it's not really left up to the employee whether or not they decide to enroll or not. They're automatically enrolled and they have to opt out of that. So an automatic enrollment is a situation where, you know, if an employee comes on, the county will automatically put them in the plan at the 5%, in this case, and then the employee would get letters from Great West indicating that they're in the plan, and if they wish to get out of the plan, they have to sign a document. They would then get any contributions that went in back. They have I think they have 90 days to do that.
Currently, it's mandatory in TCRS. It's mandatory in TCRS. They don't, the employee can't decide. They have to be in it.
Yeah, under the defined benefit plan is what Marianne is talking about. Defined benefit plan, they're automatically in that. That's the TCRS piece of it. This is discussing the defined contribution part.
So you're recommending to us that we would check box 2
Correct.
and that we would put in the date for, it says January 1, 2013 would be the date, and it would be for all employees who become eligible on or after that date?
Anybody hired after that date, correct.
Enrollment number 2A, would you have a recommendation? Should it be I or little I or little double I?
I'm sorry, on 2A,
I think he said 2I, but the question then becomes whether the date's January 1 or is it July 1 up in 2 itself.
well, I think you can put July or January 1, even though the plan actually won't become effective until July, perhaps. So, any. Right. But I guess the other answer to the question is it would be double little I, is what I've.
And on C, would it be I? On the next page, page 6.
Page 6. I would say I would be correct.
Rush, on page 7, under N, I guess that's for your call.
That's what you just voted on, and so number 2 would be checked, and then 5% entered on both lines.
Is it 5%, or are we going to match 100% up to 5%?
Oh, I'm sorry, I did read that wrong. I'm sorry. You're right. It's
Okay,
100%.
repeat it, please.
Okay, it's on page 7, letter N. Number 2 would be the box check, but the match would be 100% of the participant elective deferrals up to 5% of their pay.
On page 8, on Q, I presume that we would do number 2, and then I'm not sure if A or B is the right answer for us.
Well, I would say under Q, 1 would be probably the appropriate answer, that shall not make non-matching contributions.
So,
Correct.
Going to page 9 on item S3, or on S, would it be item number 3? Rush, did you guys discuss the matching or the vesting rate?
On a previous page, page 8, you guys did check box 3, which is a 20% after 1 year service, 40% after, that's a 5-year cliff, or 5-year vesting, I should say, not cliff.
So we should check the same box here then.
I would say yes.
My question is, since this is for non-matching contributions, would we let them be 100% eligible at the time, since that's their own money?
Oh, I'm sorry, yeah. Well, no, there aren't going to be any non-matching contributions, so there's really not a choice for that, is there?
That's why I didn't.
Since I would say, since there's not going to be any non-vesting, but in the odd event that there were, I would check 100% vested immediately. So again, you guys, there's not going to be a situation where you have any non-vested dollars or non-matching dollars.
Then under B number 2, since there will be some non-vesting periods.
It's number 2.
Number 2?
Number 2.
In B, that's correct.
On page 11, double H
is not.
And I presume under 2, then we can skip everything there.
Correct.
Are we done?
I think that gets you through the whole thing, except the very last page, which is the schedule that says classes of eligible employees.
I would say that would be full-time employees. Yeah, I'm guessing. Again, I don't know how you guys, the county classify their.
I would believe that's the right answer, but now, Mr. Parliamentarian, do we vote on this with the
Yes.
changes we've made?
What you've got now is, these changes are an amendment.
Yeah.
And so you will first vote on whether or not to accept these changes to the motion. If that passes, then you've still got to pass the original motion.
Okay.
I'll make a motion.
We already got it. All we got to do is vote.
All you got to do is vote.
We're voting on the amendment, and then we'll vote on
I
the
didn't know we
resolution.
made a motion for an amendment yet. We went through.
I thought somebody had, but I may have missed it.
Teresa?
Rick can make a motion to reconsider and accept all this, right?
He made a motion for the amendment, I don't think, or for the resolution. I don't think we have a motion
right,
for the
Kevin.
amendment. So I will make a motion to to approve this as amended.
Okay. We need a second. Thank you. Any more discussion? Let's vote on the amendment. Then we'll vote on the resolution. All right, let's have the count. 21 yes. Now, we're going to vote on the resolution. All right, let's go ahead and vote. Now, he had to get it filled out. It takes a little bit. Okay, Commissioner Alford and Commissioner Hines. All right, let's have the count, please. 21 yes. Okay, Ms. Pat. Now we're ready for 34.
Resolution 2012-34, a resolution authorizing Mayor Pennington to sign TBA contract easement.
Okay, we're going to need a motion in a second.
So moved.
Nah, thank you.
Second.
Thank you. Any discussion?
Just curious where the parcel's at, or where the property is that the easement's gonna be granted. Just curious where it's at.
Yes, come on up. Answer that question. Let Ted answer that question. First of all, did you hear the question?
Would you repeat it?
Yeah.
Sure. I was just curious as to where the property was at and where the easement's gonna be within the property.
The property is exit 117 in the Interstate Industrial Park. It's on the southeast side of AEDC Road. It's a property that's deeded to the county. Yes, sir, it is. It's across from Fisher. That's correct.
How much is the payment for?
How much they paying for it?
$26,000.
$26,100.
And I'm assuming that goes in the general fund?
That is the funds that they found to build the acceleration ramp. So
it's on the industrial property.
It goes into the industrial board to
Yeah.
use for the acceleration matching money for the state, or the.
Which at the sale of the property, the industrial board's been using that money to build buildings and make those improvements and do those matching. So that's how they create their money to do that with. Right. Okay. Any other discussion?
Question.
Let's vote, please. Commissioner, okay. There we go. Okay. Let's have the count, please. All right. Okay, we got two more items on the agenda. 3. Oh, yeah. Okay, yes. Okay, you want to do it? Okay. We're going to do the subdivision. Engage it.
Resolution 2012-35, a resolution to amend Coffee County zoning resolution number 2006-39 to allow for gated subdivisions or private road subdivisions. We have a public hearing on it at 5:30 tonight.
Okay, that's the one we added. I'll entertain a motion to accept that and a second. All right, thank you. Second? Thank you.
Would someone just summarize?
Who made the second? Okay, thank you.
Would someone just summarize what that is going to accomplish? I mean, I got to the public hearing, and the gentleman was talking, but I got here late, so just...
Yeah, well, let's let Glenn summarize it. Do you mind coming up and summarizing that for him?
A couple of things on this particular issue. When the question was posed to me as to whether or not this individual could maintain a private road, I looked in the subdivision regulations, and oddly enough, the subdivision regulations make room for it. But in the zoning resolution, the only comment was to the effect that it be a condominium type ownership. So the request, and I expressed then if it was not a public road, then I couldn't issue a building permit because the property has to abut a public road about 50 feet before I can, in effect, issue a building permit. So that was the request to add the word in gated subdivision and private road subdivisions to the existing condominium ownership statement.
Can I ask a question to go?
An example of what? I'm sorry. Oh. The issue, Stanley Rogers called and asked that question of me. He has a 9-lot subdivision off of the Rutledge Falls Road that goes down into a cul-de-sac. There's one house on that particular piece of property at present. And he made the statement that he was getting ready to deed that roadway to the county, and he happened to think, well, maybe I'd rather have it as a private gated subdivision. And that, to my knowledge, is the only one in the county, other than Lakewood Park, if you will.
Sadly, you mentioned Lakewood Park, because that bothers me and most commissioners because of the cost that we've had to subsidize or pay. If someone can close off a road and make it private, and then there are problems with those lots and any type of codes or annual maintenance fees and things like that of a closed private gated community, when we've had to try to foreclose on those properties in Lakewood, we became owners theoretically of those properties. The county has had to pay all the annual assessment fees for those properties, even though we certainly did not ever want to be owners of those properties. And I just want to be certain that we're not opening our door for that type of situation here.
No, I think in the subdivision regulations that he actually has to put together either a homeowner's ownership or a similar type of association, and that has to be approved by the Planning Commission.
Yeah, I think, let me ask it differently. After he does that, somebody builds a home and they don't pay any county taxes, and we take that home over. Now, are we going to be paying their $1,000 a month homeowners dues, or are they going to be paying?
No, I don't see that. I think in that particular and I haven't seen anything yet to come to the Planning Commission as to how it would be established.
I think we should be establishing how it is. I mean, private gated communities are fine, but I sure don't want to have 5 years from now, after they have torn up all of the roads and have to go in and dig up the entire road bed and go back through and put down all of the layers and then put all the pavement back on and then be paying homeowners association because all the people moved out because somebody absconded with the money, which often happens in those things.
Where exactly is this on Rutledge Falls Road? Where does it come off, and does it have a street name?
It's Nature Ridge. It's the street name. It's very near Sears Roebuck Road where it intersects with Rutledge Falls Road. It's within a few hundred feet of that on the opposite side of Rutledge Falls.
Hey, Bob, Mr. Husky, what's your take on what they're talking about if, will we get in another situation like we did Lakewood Park?
I guess conceivably it could, but we're talking about a totally different level situation here than we are at Lakewood Park. We're talking about a limited number of lots, and that property there, I would say, is very valuable, at least at this junction. Anything can go down. But I believe you said 9 lots, and what the status was before, you could do it if it was condominiums, but you just didn't have provision for houses, and so that's really the only change being made in making it mesh with the subdivision requirements so they're consistent. You conceivably could have that problem, I guess. Now, there has been, since the Lakewood Park case, and other counties were not interested in getting involved. Back at the time we were having the problem, and I tried to get them involved as an association. Nobody had interest until that decision came down, and now you got counties crying all over the state, and there's been an active movement to try to get some legislation. And I served on a committee that worked up some proposed legislations for these type of things, which is being submitted has been submitted to the Comptroller's office and will be offered as a bill in this legislature to make changes to that. Now, what part of it will get passed, I don't know. But if the changes that have been suggested by the county associations now and the Delinquent Tax Attorneys Association through the Comptroller's office get passed, it would provide alternatives where you don't have to pay those assessments, where you can just let the association take the property, or the assessments would be stayed. But hasn't been passed as yet.
That's sort of my concern, because Florida went through that, and they passed that kind of legislation because they have a lot of gated communities, and we don't have that many in this area. And I'm like Rush. This can leave us with a huge property problem if you have people, and you say it's a valuable land, and that it may be, but he's had 9 lots, and he's had that subdivision up for sale for, I'm going to say 10 or 12 years, and I think there's 1 house back in there. So it's not filling out very quickly, and I sure don't want to end up with people not paying taxes on something and us having to pick up the tab again. And again, I don't know what fees they're going to establish or any of those things. We ought to have in our zoning what the requirements are for them to have a gated community, in my mind, to establish, just like we're talking about what kind of bond are you going to put on the recovery of this of a property for a quarry. We ought to have some kind of controls in place saying, here's what you have to establish, and here's what the requirements are, and here's what your private contracts are going to be before we'll approve it, so that we have control, that we don't end up owing the bill on those things.
Lynn, did you say that the association arrangement they make has to get approved by the planning commission?
In the subdivision regulations, it pretty much states that, the way I understand it, that he has to have a plan to present to the planning commission.
He just has to have that, though, under state law to file it with it, and they can amend those at any point on their own without coming back to the planning commission.
Be good if we had a provision that, under no case, just written in.
I don't have anything else. I'd call the question.
Okay. I just asked the parliamentarian here, if you wanted to put that in, when you pass this resolution, you can put that, we can do amendment to make sure that's in the resolution, and, so we'll vote on the amendment, then vote on the resolution as amended.
Mr. Mayor, if I was going to do that, I would make a motion to table it and let them bring it back once the planning commission decides how they want to address that.
I would second that motion to table it.
Okay, we got a motion and a second. Let's vote on it, to table it here. Yes, ma'am. Okay, let's have the count, please. Okay. We like two more resolutions. At this time here, I'd entertain a motion to take about a 10-minute break. It would be 9 o'clock. If I could get a motion. And a second?
Second.
All right, we need to vote on it. Hold on. We need to vote on this before you jump up. Yeah, that's what he says. Can we just show hands? Let's just show hands. Everybody wants to. There you go. Okay. Let's take.
To vote on that.
I am.
We can't see.
Okay, we got everybody. Commissioner Chancellor, you ready? All right, we ready to go back to work here? Yeah, go ahead.
Resolution 2012-10, resolution amending provisions of Article 4, Section 4.047 of the zoning resolution, Resolution 2006-39 as amended of Coffee County, Tennessee.
Okay, we'll entertain a motion in a second here and get into discussion.
Motion to accept.
Okay, need a second here. Thank you. All right, we're into discussion.
Does anybody have a copy?
Discuss this resolution.
Yes, ma'am. My fault.
Oh, I'm sorry. I thought you said topic. Give me a topic. Didn't you have one?
What is it?
Once again, this is not a motion that will allow them to go out there and start breaking ground tomorrow. This is to set the planning wording back to the way it was in 2006, which is something to live with, and maybe we could work with it, as far as changing that in the future, to give this man an even playing field, where he can at least meet the criteria to ask for permission to build.
Okay, any other discussion here?
Mr. Chairman, I don't have a copy neither. I'd be interested.
here.
I think every commissioner should have a copy of the resolution since you're being asked to vote on it.
I think we
I'll tell you
all
what,
really.
I'll tell you, Roxanne, we need to go make everybody a copy. We'll take a minute here. Huh? Let's just get the two of them done. You need some help?
Mr. Chairman, while she's doing that, I'd just like to make a couple comments
Go
in
ahead.
regard to these. I've just made a few notes here, and any action by the county legislative body to circumvent the Coffee County Planning Commission and the Coffee County 20-year growth and land use plan and attempt to establish a new M2 zone in the rural RA area would be a violation of Tennessee Code Section 6-58-107 under Public Chapter 1101, which reads as follows. After the growth plan is so approved, all land use decisions made by the legislative body and the county's planning commission shall be consistent with the growth plan. Once an M2 zone has been created in violation of the section I just mentioned, in the rural area for a business entity such as that requested by the Wright Quarry operation, the county would be helpless in preventing any type of adverse, dangerous, and unacceptable business from locating in the rural area. A current action would become a precedent that would be used by anyone to force the county to create a zone for them and whatever their business interest is. Creating an M2 zone outside of UGB, where it's presently zoned, M2s in UGBs, creating an M2 zone outside of UGB for M2 industrial activities would be an irresponsible and detrimental action which would negatively impact all of Coffee County property owners and taxpayers today and into the future. And permitted uses would include such things as arsenals, fireworks manufacturing and storage, solid waste processing and recycling, waste incinerators including hospital and medical waste, scrap and salvage operations, petroleum refining and processing, mining activities and related services, adult bookstores. All those are permitted uses under M2. This county would be exposed to any of those in the rural area. Thank you, Mr. Chairman.
Thank you.
And I've got just a quick follow-up. Exactly what on 658-107 would be a violation? Pardon? Exactly what in 658-107 would be violated?
In section 658-107, under the public chapter, it says, after a growth plan is so approved, all land use decisions made by the legislative body and the county's planning commission shall be consistent with the growth plan. Growth plan, Mr. Chance says that M2s are zoned in the UGBs, the urban growth areas.
Bobby, are you saying we can never change a growth plan?
I'm saying you got to, when you're making decisions, they got to be consistent with the 20-year growth plan as Mr. Darden has related to you.
You're saying we as a county commission don't have any authority to ever change that 20-year plan during those 20 years, right?
I made my statement, Mr. Kelly. You can make your statement.
I'm just listening to you ramble over there. When the king's speaking, I try to be
Mr. Kelly,
quiet.
I made my statements. You can refer to it however you want to, but every commissioner here has a right to make a statement in regard to this. Regardless of what your impressions may be, they have a right to make statements.
Well, I guess I'd like to, if you don't mind, Commissioner Kelly, our 20-year plan was established, at least the committee was formed in 2000, and by state record it was ratified in 2005, but it was amended in 2009. So once you establish one and ratify and pass it, it has to stay effective for a minimum of 3 years. After that point in time, you can change it whenever you'd like. So I guess to answer your question, yes, it can be changed, but it's not a matter, in my opinion, which is just my opinion, it can't be changed at a regularly stated meeting or anything like that. It takes a committee formed by members of the two municipalities and the county representatives in order to change the growth plan. So the name 20-year growth plan is a bit of a misnomer. It's meant to predict and forecast for 20 years, but you can change at any point in time after that first 3-year period.
Mr. Chairman, over here.
Yeah, okay.
Or Mr. Bryan, you mentioned a list of businesses that could not go in there, and that you said something about mining. I believe Mr. Duckett said mining and quarrying is two different things. I didn't hear you use the word quarrying.
Under the M2 permitted uses, you can refer to Mr. Darden if you'd like to. That list I give were permitted uses for M2s. Anything zoned as an M2, those are permitted uses. Mr. Darden, would you like to elaborate on that?
I don't have the list here, but those are correct uses.
I've got a quick question, just for clarification and understand the layout of the county a little better. What currently do we have that are zoned M2? Where are those parcels located, and when were they designated M2?
Are you talking to Mr. Darden?
I guess anybody who has the information. No. Do you? I'd like to borrow it.
Did you hear the question, Mr. Darden? He wants to know where are some of the M2s right now. Can you come up to the podium, please?
There may be one M2, and I don't have the zoning map with me. There
Okay.
may be one M2, and I guess it's questionable whether it is an M2 or not.
What is that, Mr. Jordan?
And that's the quarrying area where the county quarries is shown.
When was it? I guess my question is when was it zoned M2?
I don't know.
If a piece has been setting for,
No, it's A1. It's it's grandfathered in.
the old county quarry has
I believe
been
it's-
vacated for some time, and I guess I was under the impression that after 1 year it would have dropped off of an M2 classification, so I was sort of wondering about the same question. How many M2s do we have, and where are they?
That's the only M2 that I'm aware of.
Well, Mr. Jordan, you're real close to your office. Could you step back and get the map and bring it around and let us take a look at it, please?
Mr. Chairman, are we looking at 1210 and 1211?
We're looking at 1210 right now. We're gonna do one at a time here, Rush. Yeah, okay.
Mr. Chairman, while we're waiting,
Yes.
I recognize that Mr. Bryan's against this proposal, and he represents some people out there in that area. And, you know, I know they're all fine people. This thing right here was put on my mailbox illegally over the weekend. And it includes 13 names of people who own property in and around that area. 3 of them that I know of don't even live in that area. And then there's only one, or there's one here that is in my district. He has never called me and opposed or shown any opposition to this. I personally called him, talked to Mr. Carden, and he explained to me that if he was to sell that 33 acres to somebody, they couldn't build a house on because the foundations would crack. Have all the foundations cracked out there so far? We've got rock crushers there that have been blasting. Matter of fact, the current blasting regulations have cut way back on what they used to. They get more gravel, more rock out of a thing than they used to. They used to just blatantly blow that stuff up and it rock fly everywhere. But I understand now, and I'm sure there's an engineer that could probably explain it easier or better than I can, that it does not impact, that the sonic booms that we experience around here are much more felt than the blasting in that area. And I recognize that, you know, there are people that are against it, but what about the other 99% of this county? I'm representing my district, my constituencies who have called me and called me and called me, and not a first one has called me that's against it. And that's the reason I'm pulling for this thing.
Mr. Darden's back now. Mr. Darden, did you find an M2 on the map? Did everybody see that where he pointed? Okay. He's got an orange sticker on it right now. If you want to, commissioners, step down and look at it so you can see. Listen, we can. Glenn,
Can I set the easel and put it up on the easel?
you need some help there, Commissioner? Well, we got the sheriff here. He's been working out. Will it set up there? Yes. All right. Mr. Darden, do you mind coming back to the podium? You need to speak up for him, too, because he has a hearing problem. Okay.
Can you explain to us, Mr. Darden, exactly where this is at and what it's representing?
Did you hear what he said?
The existing county quarry? Okay. Okay, how is it actually, let's see, they have to be, they're zoned within the county, and then the state has to take, there is state record of what the zoning ordinance or zoning parcel is, right? And that, I mean, there would have to be, it's landmarked in the county as far as what the existing zoning ordinance is, but there's also a provision that goes to the state to show what we've done here. So seems to be some confusion or conflict as to the other existing quarry in the county, because I was under the impression when I was on the planning that it was an M2.
No. This is the '06 map. It's the only one I've ever operated with.
Mr. Darden, there's a huge map on your wall. Is that not an official map also?
This came off of my wall. That's the official
It used to
map.
have a dot on it that said that Rogers Group was M2.
That's the official map that was approved in 2006. That's one I'm using today. It's true there's other maps in there, but this is the official map. No, no. It's just like, it's another business out there. It's allowed kids to
I know that. Mr. Darden, does that map show us what would be the urban growth boundaries?
This dark yellow is and the lettering UDB, the urban growth boundaries for Pelham area. This dark green area, the city of Manchester. And it's
Mr. Mayor, can we have St. John Engineering come up? Because I remember back during this timeline, and they were, to my understanding, they were very instrumental in constructing these maps and setting these parcels in these zoning areas. And I would really like to hear from the individual that actually created the map.
Okay. Mr. Darden, if you don't mind, come back up with him so that when he's going over this.
I don't have anything with me as far as the latest map.
This is the latest map. I guarantee you.
You need. Hey, you two can come up there and look at it if you need to. Do you need to look at the map?
The latest zoning map that was prepared, and I don't know the date, it does show the Roger Freeport accident. The last time we were here, and we brought up that very fact, and Mr. Darden said that was a mistake, that it was not supposed to be an M2 zone, that, it should have never been zoned into, but acknowledged that it was, and,
Would it not indicate on maybe the deed or something in the Register of Deeds office along with the parcel that designates what the zoning is? But beyond that, we had in 2009 an updated 20-year growth plan, and along with that is supposed to be the updated zoning maps. And
if you updated the growth plan in 2009, and there should have been an updated map in 2009 as well. And right, I personally, in our office, was not part of creating that map. We have a copy of that map, on our wall in our office. But if 2009 was the last time that this plan was revisited and approved, then there would be a 2009 map as well.
Ms. Darden, do we have a 2009 map since that's when it was?
No, I don't have it. This is the only map I have. It's the only one that's signed. It's the only one, to my knowledge, that exists and it's in the
It was 2009 that you last approved the plan, and there is a 2009 map that went along with that plan. I'm not saying you have it, obviously you don't, but there is a 2009 map. And it does not show the county board as being an entity, but it does show the park.
I guess the zoning of a parcel, is it not indicated on the parcel itself in the Register of Deeds office? Okay.
It was part of the action when we approved the
new zoning map for the entire county in that plan. It included new designations that were to be made that came through the planning commission. They were approved by the commission, and that established the new sets of boundaries. And that was my recollection, was the 2009 map that had those changes on it, and the urban growth boundaries that are on this map are not exactly the same. They're a little bit. I know Tullahoma's changed some from what's shown on this map, and Manchester was as well. And then I think we designated a boundary around the area, or someone added it afterwards, but there was a boundary put around the Hillsborough area, and I don't really recognize it on this current map here.
Do you recall what kind of boundary was put around the area? Because
I do not, but it was from the time it was put together, it was moved to make sure that this property was removed from it.
Mr. West?
I was just going to say, we're just a little bit off track here. We're talking about this M2 and stuff, and that's actually in the second resolution. Right now, we're talking about the correcting a problem that was corrected once, voted by this group to correct it, and then it's been thrown away again. And all we're saying, let's do that one first, and then we'll talk about the other one. Question.
Mr. Chairman, I was just wondering, are there any other business entities that are requesting, this change in the zoning plan? And I don't know, maybe Mr. West may know. Are there any other business entities requesting a change in the this change in the zoning plan?
We mean this change.
These resolution changes you're proposing here that would create an M2 zone outside UGB. Are there any other businesses that are requesting this?
Not in that area, no.
Only Wright Paving.
As far as I know.
Thank you, sir.
I guess I'll ask the other question. We got any businesses?
Commissioner
out there
Duckett and
to
Commissioner
put
Brickman?
anything else in the county to rezone?
Are we dealing with 2012-10? That has to do with the reclamation costs.
Yes.
Okay, that's not what we're talking about. I might point out again that it says, in the case of mining operations, a reclamation plan and reclamation bond in the greater of $2,000 per acre for each acre proposed to be classified within the M2 Special Impact Industrial District, or $95,000 for each project. We're talking about mining operations, not quarrying operations. They're not the same.
Just me. Commissioner Bricken, then Commissioner West again.
Well, Commissioner West is right. I mean, if we're talking about Resolution 10, which is strictly trying to discuss this reclamation issue, and of course earlier tonight we tabled the zoning board's recommendation, tell them to go back and get better facts and information of what other states and other mining, quarry, whatever you want to call it, has reasonable reclamation. I mean, these numbers, and I agree, there's been a lot of debate whether $2,000 per acre is high, low, or indifferent. $95,000 per project is high, low, or indifferent. I have no clue. It should be reasonable. I mean, but this is secondary to the M2, because I mean, if you don't get 11 passed, you'll never have a need for reclamation. So I'm not sure if we got the resolutions in order right, but it should be something reasonable. And obviously we asked the zoning board last June or August to come back tonight with a recommendation. We got what we got. I think we sent it back because we didn't like what we got, and I agree. It's wrong to have something as vague as that to allow any business, because, again, and I don't think should be talking about right paving at all. We should be talking about any business that wants to come in, and we might discover something real valuable more than rock out there one day, and we should have an avenue to do something with it if we ever find it. So I don't know. I'm about to sit here and say, send this back, but we want a reasonable figure based on what other counties and other states are doing with this, and we just don't want. Obviously, the zoning board is totally against anything dealing with a quarry or a mine or anything, and that is just prohibited. I mean, businesses need to have some avenue that is reasonable. It doesn't. And right now it's so pinholed that it's absolutely ridiculous. So again, I can't get fond of this. I can't get fond of that. So I'm not very fond of anything right now.
Commissioner West, and then Commissioner Fan.
Mr. Rickon, these numbers were on the original thing. That's all there are. I mean, if they need to be raised, they need to be raised. I don't think that Mr. Wright's opposed to that. He has some reports showing where the state of California charges $5,000 per acre, and I don't remember what the maximum cost was, but it was reasonable. It was bondable. Arizona charges $400 an acre. What does Tennessee value their land at? That we tasked them to come up with those numbers, and they didn't. They just come up with the same stuff that was in the book. If we could pass this back like it was originally in 2006, and then amend it appropriately, I don't think the Wrights would have a better problem with it, or any other organization or business that's coming in here.
Commissioner Fan.
He said kind of what I was going to say, but I will say this, my personal opinion is, and it has nothing to do with Tim Morris and Mr. Duckett, because I think they've done an excellent job. But I feel like that Mr. Darden has been thrown under the bus by the chairman of the Planning Commission, because I feel like she should have been here to go over all this. But I can't understand why a few years ago, LKQ was allowed to come in and do a junkyard, and in a junkyard they have oil on the ground and everything, and before they can sell that land, if they ever choose to, they have to clean that dirt up. You have to dig down so far and get that dirt cleaned up. Same thing if a scrapyard hadn't bought our junkyard or a parts yard, we would have had to clean that dirt up. So it would only be natural that anybody that put in a rock quarry or whatever would have to clean it up if they moved. But I find, and we were grandfathered in at the salvage yard too, but I find it so strange that LKQ has come in and put a salvage yard there, which is nothing against them, but they are right at the city limits. And you've got CFC in Tullahoma right there on Tullahoma Highway, and it's neat as it can be, and it's a scrap metal place. The people that bought our yard, they bought it as a parts yard, but they put scrap metal in, and they didn't have to come before anybody and get a thing to scrap metal, and that's their main business. They've let the parts go down. I just find it very strange. It's kind of like it's I can't even think of the word. It's just not right. We don't have a set thing going. And I just think we need businesses in our communities, and I love this community, and I just think that but sending it back to the Planning Commission is going to be the same thing all over again. All it is just more time. We could fight this for another 2 or 3 years if we keep sending it back to the Planning Commission.
Commissioner Chance.
Yeah, I just want to add a few things, and I don't disagree with what Commissioner Fan was saying about the locations of these different businesses and whatnot, but there is a defined plan, and that's where I think we need to have some, when we're talking about not the reclamation issue, but actually the zoning issue. I think we have to have clear and cut and defined legal opinion as to whether or not we are allowed under state law to change the zoning outside the planned growth area. And without knowing that, then we may be placing a vote that is not legally competent. And we need to be aware of that before we take that into consideration, because when you've got Title 13 and you've got Title 6 and they're contradicting each other, and it says in Title 6 that if it's outside the planned growth area, you can't change it. But then our county attorney has Title 13 that says you can. So I really believe that we need to have clear-cut legal guidance saying whether or not we can actually consider it to be changed, because if we don't, then we're just shooting from the hip, and that's what causes problems when you're shooting from the hip.
Okay, the attorney probably has something to say.
May I make a suggestion then, in light of you're bringing that issue up, combined with my concern about the public hearing on the matter? Why don't we schedule a time for a public hearing on these two ordinances or these two resolutions? And during that time, I will get those code sections you're talking about and see how they compare with others and consult with others if I need to do that, so I can better advise, because I'm looking at a section that says that there's a lot of confusion in the ordinances. There's a lot of confusion in our zoning ordinance, and it's copied straight out of statute, and a lot of the wording of the statute is very confusing, and it with that, I think with all the problems pending, I think Commissioner Chance has a good recommendation. Let's don't vote until we're real comfortable with the situation, regardless of which way we want to vote.
And I want to clarify that I don't have a problem if that's what the legislative body decides to do, is to vote on the reclamation issue. It hasn't changed, and I don't believe it requires a public hearing for that. But the other one, there's a legal issue that needs to be clarified, and I would rather see the second one at least get the clarification, so we don't cast an illegal ballot, or not an illegal ballot, but a vote that's outside of our authority with state statute. And that's my main concern. And I understand the LKQ and things like that, but that lies within the urban growth boundary, and it's allowed under Title VI. It's allowed. If it's outside that preferred growth area, it says in Title VI you can't change it. So I think I would like to see some clarification on that before the 2012-11 is decided on, but I don't have a problem with 2012-10.
Commissioner West.
I appreciate y'all's opinion or your statements on that, and I've read Tennessee Code Annotated. It's written by lawyers for lawyers. I don't understand any of it hardly. I mean, it's difficult to understand at best. And we have another lawyer here in the audience. I'd like to hear his opinion of whether it's legal or not legal.
We did have three others in here. I think we're down to two.
If you're talking about, we'll have the attorney. We'll give the attorney from the Wright Group 5 minutes, and we'll give the Hillsborough Group 5 minutes.
Yeah, whatever attorneys are here.
Let's let the Wright Group come first, and then we'll let the Hillsborough.
Thank you, Mr. Mayor, and thank you, members of the commission. My name is Evan Cope. I practice law in Murfreesboro, and I represent the Wright family. And I'll say it's been a long night. I know you're all tired, and I'll try not to take all my 5 minutes to deal with this issue. But I think this issue, from my point of view, has gotten a little bit convoluted. It's gotten clouded. It's really pretty straightforward. I think we can all agree that we can't ban rock quarries in counties in Tennessee. You can't ban them. They're lawful uses. And there are two ways. You may say and look at the face of this, and I'm talking about the ordinance, the resolution you have right now. As it stands, if you look at that, it doesn't say rock quarries are banned. But what you have to do, you have to look beyond that. You have to look behind it and say, what is the net effect of this zoning resolution on rock quarries? And if the net effect of this zoning resolution on rock quarries is to prohibit rock quarries because they can't comply with the zoning area where you say they ought to go, then the net effect of what you're doing is you're outlawing rock quarries. Courts aren't going to just look at what you have in writing. Courts are going to look beyond that. Courts are going to look to say, what is the effect this law is having on businesses like the Wrights? But let's take the Wrights out of the picture. Anybody that's wanting to operate a rock quarry is going to have the same issue as what the Wrights do. So I would urge you to think about that on the front end. You have a resolution before you in 20-10, I guess if it's 10 or 11, whichever one deals with them too. And this conversation about whether or not you can change your zoning ordinance, it's my opinion, and when you get 3 lawyers in a room, I'll tell you, it's like getting 3 doctors' opinions. I mean, everybody's got a different opinion. And there's really only one opinion that ultimately counts, and that's a court's opinion. But I can tell you from my perspective that a county legislative body has almost unfettered discretion to legislate zoning and land use in their counties. There's nothing set in stone about a zoning resolution. It can be changed. The urban growth boundary, no one here is asking you to change the urban growth boundary. It's set. What we're telling you is that the zoning that you're allowed within the urban growth boundary for M2, in a practical effect, denies a rock quarry the ability to operate. So that's the situation that you've got here. In terms of the reclamation, and I'll touch on this and I'll be happy to answer a question if I can, but on the reclamation, you have the same issue. You've got a resolution that says $95,000 an acre for reclamation. There's no surety company in this country, I'm willing to say, that would issue a bond or a surety on that amount. So again, you're not saying in writing, we're banning rock quarries, but when you set the reclamation amount at $95,000 an acre, what are you doing? You're making it impossible for anybody to get the bond. You're making it impossible for anybody to operate a rock quarry and do business in this county. That's the net effect of it. I understand, Commissioner, I can see you have a question.
Well, I don't disagree at all with what you're saying about the reclamation issue. Where I do have some disagreement is there are quarries in Tennessee within urban growth boundaries. There's one in Nashville. It's right across from Harding and 24. I believe there's also one in Lewisburg. So it's not completely out
Is
of...
the whole county up there urban growth? It's a metropolitan area. It's all urban growth.
Right, it's all urban growth. I mean, I'm not saying it's not, but to say that quarries cannot occur within an urban growth boundary, I don't believe is entirely factually correct. But I want to know, and I think it's good for us all to know, is if we have the ability to change zoning, we also have a process we have to go through, and that would be an amendment to our 20-year growth plan. Another amendment to it, another change to it, a revision to it, it sounds like to me, because that's what establishes the zoning areas. So would it not require then a change to the 20-year plan, just like there was in 2009, to allow for that, because then you're not doing just the spot vote zoning that I was talking about in Title VI.
Well, one thing, Commissioner, and I'll do my best to answer your question. We're not here today to rezone anything. If I understand the situation correctly, there is no M2 zone in the urban growth boundary at this point. There's none. Okay? So somebody, if you're going to have an M2 zone in the urban growth boundary, somebody's going to have to come forward, whether it be the Wrights or anybody else, somebody's going to have to come forward and say, make application to rezone to M2. So as it stands right now, there is no M2 within the urban growth boundary. I don't think, my opinion, and again, for what it's worth, that and 50 cents will buy you a newspaper, it does not affect this county's ability to change the zoning within the urban growth boundary or outside the urban growth boundary. You're not changing the urban growth boundary. You've got the right to zone it. And I think you've got a really serious problem, with all due respect, with your zoning resolution with regard to how it treats uses like rock quarries at this point.
And I'm not going to disagree with that at all. And I'm not making an argument for or against. I'm just trying to get clarification. And I don't think we'll be able to get it tonight as to what is legally allowed under Title VI. That's my main concern. Whenever I cast a ballot, I've got to make sure it's legally defensible. And that's what I'm trying to determine, is whether or not I can cast one that's legally defensible according to 6-58.
Well, I've got 6-58. Are you talking about 658-112? Okay, I think you mentioned, Commissioner, earlier, A subpart 3. And again, you have a county attorney who's a great attorney, so I'm not advising you legally. I can't. Okay, but you're asking.
Wait, you can go ahead.
Thanks, Mr. Husky. I've got plenty of work. I appreciate that. So, but I'll tell you what it says is a county may establish separate zoning regulations within a planned growth area for territory within an urban growth boundary or within a rural area. This, to me, is permissive. It's saying you can do it.
Within a planned growth area.
Or in a rural area.
And that's where I think we need to get some clarification, because it says within a planned growth area you can make these special provisions as long as that urban growth area and that rural area are within the planned growth area, because the planned growth area encompasses all of them.
Well, I still don't think that this, and again, I know we disagree about this, but I still don't think this statute has any effect on this legislative body's ability, legally permissible ability, and this has been the case for as long as I can remember, to legislate land use in the county.
And
That's a lot of what you do.
Yeah. And I guess from my understanding as well, ultimately, I guess if we wanted an opinion on it, then am I correct in assuming that that would be something that the Attorney General would have to issue an opinion on?
I didn't get
You have your county attorney, and he's the one that issues those
Well,
opinions
that's what I
to the
was
body.
saying. I want a chance to review that in conjunction with this other, the chapter 13.
And if I could just touch on one other thing, and I don't, obviously, it's whatever the pleasure of this body is, whatever you want to do tonight, obviously is what you're going to do. And I really appreciate you all giving me the time to address this issue and to talk to you about it. The last point I want to make is you've got two resolutions that are before you tonight. They're the exact same resolutions that was before you back in, I think it was it June? June of this year. Nothing's changed. No wording has changed. The Planning Commission didn't alter or amend these resolutions whatsoever. They, from as best I can tell, they submitted a report, which is meaningless because it doesn't change the zoning resolutions that are before you or the resolutions that are before you tonight. So with all due respect, I don't think you need to have a public hearing for resolutions that you've already had a public hearing on. Now, if you had a new resolution that came back where it was changed or altered in some way, I would say, yeah, absolutely, you should have a public hearing. But you've already done that. And if you go back and look at the minutes of your meeting, at least the transcript that I have, I think it was anticipated, and I don't want to speak for you all, you can speak for yourselves, but the way I read it was that you anticipated coming back here on this night once you had a report back from the Planning Commission, and then you would make a decision tonight, not put it off 2 more months. And I heard a comment made, well, who's it going to hurt? It hurts business.
Okay, I think you probably had more than 5 minutes, and
Yes, sir.
we're going to let the other side.
Thank you.
I think about
Mr.
10
Mayor,
minutes there.
before that happens, I'm going to add one comment to what Commissioner Chance was saying. Just from a personal...
You can step on up, ma'am.
From a personal experience of having sued over this kind of issue, and the judge's ruling was, in that case, the municipality decided it would completely ignore its written requirements for zoning and do something entirely different. And the court's ruling, Coffee County Court, ruled very straightforward. They have the authority to do it how they want to do it, and the judge ruled in their favor. So, you know, I believe we have the authority to set our own rules. That's what we're put up here to do, and I'm not sure why we don't think we can do that this time when we do it on everything else.
Okay. Okay, ma'am.
Hi, everybody. I know it's late. I'm Elizabeth Murphy, and I agree with council over there. I have 2 rules and a state regulation, and we've been fighting about it for 3 years, and it's just on its way to the Supreme Court, state Supreme Court. So interpretation is everything. So here's what I know about what you're trying to deal with. Commissioner Kelly, you've raised a good point. The state legislature gives you broad power to zone or not zone. It's your power. If you want to keep house in your county, you can. If you want to throw the doors open and say any landfill, any quarry, any adult bookstore, come on in, plop yourself down where you want to, you can do that too. If you have a growth plan, though, the prevailing wisdom is that you are to follow it. So the question that Commissioner Chance asked is a good one. Are you likely to open yourself up to legal challenges if you pass this resolution? Probably. Why? Because it affects the entire county, and right paving is who wants it. Currently, your zoning does not preclude quarries throughout the entire county. It doesn't. That's if you had done that, that would run afoul of a case called Browning Ferris, which I'm sure council's familiar with. We all are. It's when you completely exclude a particular business that you run into trouble. You have to completely exclude it. That's not what you have here. What you have here is a business that owns property in a location where they're not zoned for what they want to do. And so to fix that problem, they want to strip out your M2 in the UGB rule countywide. So there's what you can do and there's what you should do. It's not that you really don't have unfettered power. So I think that was a little bit of a reach there by council. I'll just respectfully disagree with them. You do have limits. You're supposed to be looking at the health, safety, and welfare of the whole county, not one particular entity. So that's your charge. And if you run afoul of that, yes, you can get in trouble with the court system and the litigants who come up and challenge you. You have a lot of options. You can expand your UGB. You can fix a lot of the inconsistencies that I've heard about tonight in your zoning with a number of tools. There's float zoning. There's lots of things you can do. I just don't hear any other problems really coming up except Wright Paving. They have a particular interest, which I understand, and that's what they want to get fixed. But they're going to do it at the cost of taking out that industrial protection countywide. So it's Katie bar the door at that point, and you really should understand that before you pass that resolution. One of the things that, other perspectives I bring to the table, and I'll try to make this short, I spent a lot of time in my office answering one question: how did this happen to me? Rich landowners, farmers, middle-class landowners, small businesses. A landfill came in next door to them. TDEC handed out the permit, which they do every time, and all of a sudden the landfill wasn't making as much money as they wanted. So they thought, well, we'll get a different type of waste. We'll get an industrial waste because we'll make more money. So they go to TDEC. They ask for the special waste waiver. TDEC hands it to them. Why? Because they're getting a check. They never say no to that either. And next thing you know, you got an entire neighborhood, and literally aluminum particulates are falling on their house, and people have rashes, and the dogs are throwing up, and they're saying, how did this happen? It's like, well, go talk to TDEC. And guess what? Then go talk to your commissioners because they have no zoning. So I can tell you about toxic body farms that have gone into properties where someone just had a creative idea about what they wanted to do to make money. Literally, bodies, toxic waste, laying on the ground, rural farmers around them saying, what are you doing? There is no end to the creativity and what can come to you when you just strip out the protection you have. And that is, I think, what all the rural landowners are very concerned about. I have cases where people's wells are blasted out, their houses are blasted out, the quarry is open, there's nothing left but a hole, they went bankrupt. 5 of them just filed for bankruptcy this summer. It just is really not what I would call a growth business. I would hope Coffee County would want to attract something a little bit more higher paying and longer lasting. There's lots of options out there. The last thing I wanted to add is there was something on the reclamation issue about the 5-year issue. That's probably in there if this is informational help. Almost all of the TDEC permits are on a 5-year cycle. So they go back up for renewal. It's usually a pro forma, it's not a big deal, but they're usually on 5-year cycles. So if you have a 5-year cycle in your zoning, you're probably matching up with what the state does, and that's a good thing. Because you want to kind of, again, your housekeeping, you're managing your house. You can just keep letting it go and letting them continue with what they're doing, but they don't have to fill the hole in and start over. That's not a concern that you should really worry about. I do agree with him that the $90,000 an acre is far too high. You need to fix that. But that resolution is hotly opposed by rural owners who are going to be subject to just about anything. I have those cases for a living. It is a very sad state of affairs. If you've got the protection, I strongly recommend you carefully consider keeping it, because you can fix all your other problems and you have not run afoul of what they call the Browning-Ferris rule, because quarries are not completely excluded. It's just not where Wright wants it, and I understand that problem. Sorry. The Browning-Ferris case, I'm abbreviating it, but I read the case again before I came down. It's very clear language. It says you have to completely exclude the business, and by the way, if you wanted to completely exclude quarries, you could, because the Supreme Court said, go ahead if you want to, just have a good explanation for it. So, for example, Coffee County could say, we have karst topography, we have caves, we have underground streams, so if you're blasting around here, we might have some sort of structural collapses. There are sinkholes next to the area on the other side of the hill where this Wright project is. And if there's a geological report, which I think some of you got in the packet that I think Commissioner West complained about in his mail, someone went ahead and took a look at that and said, you're in one of the heaviest cave zones that you're going to find in the area. Blasting is not necessarily good for that. You can destroy your groundwater. You can damage a lot of things. So if you had a reasonable explanation for getting rid of the quarries completely, it would hold up in the state Supreme Court. You just have to have a good explanation for what you're doing. It can't be, oh, this guy wants it, so I'm going to give it to him. So that's the Browning-Ferris rule, and I just wanted to kind of run that by.
Any other questions from the commission, Terry?
I did read the geological report, and apparently the caves out there right now are not affected by the other rock quarries. I mean, this one here is going to blow up the whole county, and the rest of them didn't.
No, they're...
And I respect your opinions and everything, but Katie's not going to bar my door. If we want to keep a business out that's going to have nuclear waste here, we're going to vote against it. We have that right to do that. Now, how many people can you keep from suing this county? None. Everybody has the right to sue anybody. By threatening with legal mumbo jumbo or lawsuits, I don't buy that. I mean, anybody has the right to sue us for what we think or what they thought we did wrong. But if we prove in court that we did right, like you just said, then we're all right. Nobody else is going to bring that up and try to sue us.
You actually brought up a very good point that I would like to address. Wright Paving sued the city of Shelbyville, and the appellate opinion just came down in October. And the city is now, I think, looking at a very stiff attorney fee and penalty. Part of the reason was they had a quarry on property that could be a quarry. When they went ahead with their permit application, you probably know the story in greater detail, that's when the state started to balk and go, well, wait a minute, we're not sure we want this quarry, and they delayed putting it on the agenda, and they got into a whole bunch of trouble, and now they're looking at a very, very adverse judgment. The city of Shelbyville is looking at adverse judgment. Why? Because it was already allowed. And so that's the problem with this resolution you're looking at now. Once you say M2 is no longer prohibited in the rural areas, once you take that prohibition away, I will respectfully disagree with you. It is Katie bar the door, because the next business that comes says, you did it for them, do it for me. Now you're into the arbitrary and let me just finish. Because a landfill is in that same category that you've got listed in your zoning. And so you really want to be thoughtful about that. I'm not telling you what to do. I'm just saying that's another case where the city ended up in a lot of trouble, and they've got a big bill to pay, and Wright took him to court, and I'm not sure if this attorney representative... Right, there was not a quarry. That is correct. It was just available to be a quarry, and so they were trying to pursue their rights, and that's how it ended up. Wright was very successful in that case.
Okay. Is any other commissioner?
I have a question. Several years ago in this county, they put in a land fee. Okay, it was on donated land from Arnold Engineering and Development. Time it was put in, it was supposed to have certain sections where you would put certain things. Okay, but instead of that, they were allowed to come and just dump everything in one section. So we wound up with wells that had cadmium, chromium, mercury, because they had no reclamation. None. Mr. Wright has a reclamation thing. On the ones that are grandfathered in, they have no reclamation. Mr. Wright has a reclamation thing. So your whole point, to my mind, is totally invalid.
Which point?
And I would like to add to that as well, because I've got intimate knowledge with the Coffee County landfill that was donated, or at least it was a municipal landfill not only used by the Air Force, but by Coffee County as well. And let me finish. And the reason why it was you find cadmium and things like that, and even off-site methane, is because it was put in place before the 1984 Hazardous and Solid Waste Act, which governs landfills. That's why it's got the problems it's got. It's an unlined landfill. And anything that's put in now, landfills are all required to be lined and vented and all that kind of stuff with impermeable layers. And And the problem is, that one's not because it was opened in 1971 before the EPA existed.
And by the way, I have 2 leaking landfill cases right now, and I just settled one in federal court. They almost all leak, and anyone who thinks that they don't, just give it a little time, and it'll get there. So you better. Those reclamation bonds are subject to a lot of question because you really don't know what you're getting into, and once they're permitted, you don't know what kind of waste they're taking. It's up to TDEC. The county's out of it. So
Okay.
those are some of the issues.
Can I ask you one more question before you leave?
Sure.
We're talking about not having an M2 in the county, in the rural areas. But it's permitted in the higher density populated areas of the urban growth areas. So explain to me why that's in the better interest of the county to be able to put this kind of operation where there's a lot more people, next to schoolhouses even, and not out where there's less dense population in open area that would help protect the general population.
2 things. First of all, I am not admittedly as familiar with your population densities here. Coffee County did not appear to me to be particularly densely populated. Maybe Commissioner Bryan can speak to that, or another commissioner, because my understanding was that there's areas in the UGB that are not particularly densely populated. There are there's 2 quarries in Metro, and one is, I think it's on Richardson Creek, and it's in an area that's somewhat populated, but again, it all has to do with your practices and what you're doing, and the levels of control, which have a little bit to do with Metro. So, and I think there are probably ways to grow your UGB out, because you may have someone else that comes in and wants to do it, but what you're looking at is taking away the whole M2 inside the UGB rule. You're just stripping that out completely. So that's what opens the whole county to it. So then you no longer have any
what that's
control.
doing is it's opening the whole county to it, as opposed to only high density population areas in the surrounding cities. It's opening the rural area up as well.
Right, I see your point, and I think the solution for the county is to maybe look at whether they want to grow a UGB or come up with some other zoning, if you think it's too constraining, but I can't really speak to your density, where it's located in the UGB. Quarrying, right. From my case experience, I tend to tell people quarries and landfills should go places where there are not established residences, there is not groundwater, there is not a lot of surface water, and there's no Karsten Cave. Where you've got Karsten Cave, you are going to have dropouts, voids, and we'll find pollution 5 miles away because the stream got polluted and we found it, somewhere else, miles away. I didn't know about that until I started doing this kind of work in Tennessee, and I was amazed at what you have in the state. It's really quite wonderful and unique, but it's not a good place for landfilling, and it's not really a great place for some of the quarrying activity that they put there. But that's just my humble opinion.
Okay, I think we've asked for enough questions on both sides there. Okay, Commissioner.
All right, I'm going to take it. Can I?
Yes, sir.
I'm going to take a shot at trying to move this along. I certainly don't like Resolution 11, but 10, I'm going to make a motion. I'm going to make a motion to amend the dollar amounts and then call for a question. Whether it goes up or down, we'll see. But I'm going to move the $2,000 per acre to go to $4,000 and double the 95, round it off to $200,000. I'm not sure what a definition of a project is, though. So I'm bothered with that word, but I do want to double the dollar amounts just to have another number that's better than these numbers. And
you're making that in form of a motion?
Amendment
for
to
amendment.
the right.
Mm-hmm. Rush, I would question doing that for one reason, and that reason is, I think if we amend this from what has been setting before us since June, that we ought to go back and have the public hearing as the attorney said.
Okay, right now we
So
don't
I'd
have a
ask you-
second.
I would ask you to withdraw that before we have to deal with it.
Then I would request you to make a motion to have a special meeting or table this thing.
Before we do anything, Commissioner Duckett's got his hand up.
I'd like to point out one more time that you cannot substitute mining for quarrying. Not legal.
And I disagree with that. Mining operation is the geologic extraction of minerals and ore.
Not according
Calcium
to-
carbonate is limestone, that's a mineral.
Not according to the state law. There was a bill in legislature to include quarrying as mining, and it failed.
Then what is a quarry?
Quarrying is quarrying, it's not mining.
Define it for me then. And
I'm-
where in
I'm
state law
only-
does it say
I'm
that?
only telling you what the state will allow, okay?
Okay. All right, we're not getting
I'm not
nowhere.
trying to define it. I'm telling you that quarrying and mining are two different
Okay.
issues.
All right.
I don't care about
Rush,
your law.
Rush had he made an amendment. Did we get a second? If we don't, then,
I actually withdraw my amendment
Okay.
and consider, I like to just, again, I think these need some attention, and unless we're going to spend another 4 hours or at a special session, and that's fine. I mean, or get something moving on this thing. And again, I think we have just bottlenecked this thing badly. I'm really disappointed, sadly, at the Planning Commission not having a reasonable avenue for this, any business. And again, I don't think it's a rights issue. It's for any type of mining, any whatever in our county. And it bothers me that we don't have some reasonable avenue for that. And I don't understand why the zoning board can't get their heads around that.
Commissioner West.
Mr. Brickett, if you allow us to go ahead and vote on this, or not allow us, but we'll go ahead and vote on this, and if it's passed, I will guarantee you that I'll come back with another resolution at our next meeting amending those numbers or changing those numbers. The rights are acceptable, that's acceptable numbers to them. That can be bonded, and there's not a problem with that.
All right. Question's been called. Let's vote. Yes, we can. We can. Are we too late to do that? Okay. You got the roll?
Request the rural commissioners be polled first.
Okay. Do we have the roll book? Yes. Hold on a minute. We're going to have to go get the roll book. Is that right? Have you got it? Okay. We're going to do the rule first. 10 on. Okay.
We're voting on Resolution 2012-10 as it's worded.
Yes. Okay. We'll have a roll call. We'll start with the rule. Manchester, Tullahoma. Do you need some help? Do you need Roxanne? Let Roxanne give you a hand there and show you. Just, yeah.
Okay. Bobby Bryan,
No.
Janet Fan, Eric Chance.
Yes.
Carrie Farah, Lee Duckett,
No.
Virgil Alford, Barry West, Tim Morris, Rennie Bell, Keith Thacker, Mark Kelly,
Yes.
Robin Hines.
Well,
Huh?
well,
Oh, okay.
well, she's already got, go ahead and keep going, Roxanne. Do Robin Hines.
Robin Hines. Jimmy Bradford. No. Myra Patton. Jackie Duncan. Rush Bricken. I know his name's not written down here. I'll come back. Gary Kidd. Warren Walker.
Yes.
Stephen Jones.
Yes.
Wilma Thomas.
No.
Sam Mai. Yes. 6 no. And 2 abstain.
Okay. Passes.
I make a motion to table 2011.
Is there a second on that motion? Okay. Okay, first of all, Rush, we got to get it on the floor, then you can make that motion. Let Roxanne, 11, go ahead and do resolution. Then we'll get a motion.
2012-11, a resolution amending provisions of Article 4, Section 4.047 of the zoning resolution, Resolution 2006-39 as amended of Coffee County, Tennessee.
Okay, I need a motion and a second.
I approve the motion.
Okay, we need a second. Okay, now Commissioner Bricken.
I move we table this to the next meeting.
Okay, do we have a second on that?
Do we want to table it, or what was the other deal?
Well, motion to table. The motion to table puts it on the table till someone makes a motion and it passes to take it off.
Someone, anyone?
Anyone. Or, if you're wanting to put it off till a particular time, then you would say postpone it till that time.
I would like to postpone this to our next meeting and call a public hearing for that time.
Rush, could you do that so we could have a meeting in December and move this along instead of waiting to January?
We'll have to have a special call meeting.
Yeah, I understand that, but
$3,000.
we've been sitting on this sucker for 3 years. You think we
Well,
could eventually do something?
You know, I just don't think the January meeting's agenda is going to be that heavy, and I hate to cause the cost of the county of another meeting. So that's my...
Did we get a second on the Commissioner Bricken? Oh,
You just got a
seconded?
motion to postpone. I hadn't heard a second.
We got one over here.
Okay.
Okay. So we need to vote.
Well, you can debate a motion to
Yeah.
postpone.
Okay, this motion is to postpone. Do you,
Yeah, Rush, again, I'd still hate to see this thing sit around and sit around and sit around. And
any other discussion?
Yeah, I've got just a quick question about this. Is in the interim between now and the next meeting, whether it be December or January, what is the intent of accomplishment? What are we looking to accomplish, and why? If all we're doing is postponing for the sake of postponing, what do we hope to accomplish?
Well, my best one is that I just hadn't heard any great arguments that convince me one way or the other. I think that's been the issue dealing with the state, this UGB, whether our current growth plan can be modified or not. By making this change, exactly these arguments, how much are we opening up, or are we just telling the zoning board, Mayor, if you get a request, act upon it reasonable. You don't have to approve these requests or not. I mean, if you look at, actually 2011, it says the zoning board will get all that information and either approve or not approve the project. If they don't want a quarry, the zoning board can certainly, under what I hear of 2011, could vote it down there, but at least any one business would have a right to have an avenue. But more than this, I'm just worn down.
Yeah, but you also said you wanted to have a hearing in between that too.
And I think so. I think this has gone on. I think everyone, all the stakeholders in this, and we've had somewhat of a qualified public hearing tonight, and therefore, you know, whether we have a public hearing or we have the same folks back, I don't know. But sometimes a public hearing, we have it, and then we repeat everything at the public hearing when the resolution comes up. So I'm not sure if we just cost ourselves an extra hour.
But Russ, nothing's going to come forward that's changed from what's on here. I mean, we don't have, if you send it back to the planning commission, it'll get muddled around and nothing new comes out of it. We've held public hearings on this thing already. We've had all the input. You know, we listened to the same arguments for the fourth time. Yeah, I'm sort of with Eric that, you know, there's nothing changing. We're just coming back with the same thing, and we're putting off dealing with it when we ought to go ahead and deal with it.
Well, and I'd like to amend a little bit of that because...
Okay, we got a motion to postpone on the floor. Let's vote on it.
Mr. Mayor, there's still discussion going on.
I thought you was through there. I thought you was too.
Right, and I wanted to be able to, I think it's prudent that we provide some sort of direction to our legal counsel to say, we need to know what we are allowed to do legally under state code, whether it's guided under Title VI or Title 13, which one is it, and what is our legal authority, because it will decide ultimately who we get sued by.
I'll add that to my postponement to direct our counsel to give us a full report on the pros and cons of adopting this resolution.
Any other discussion? Let's vote.
We're voting to postpone, is that correct?
We're voting to postpone. Yes. Okay. Okay, it passed. We're going to postpone it to January. That's what it was said. Okay. Any statements and announcements from the full commission?
I've got a question I'd like to raise, and since Bob's going to have other work to do, pass this along to him also. I have been sent several pieces of documentation from folks who have asked for outside opinions concerning what happened at our last commission meeting, in which we had Commissioner Bradford nominate himself for the position, going back on the ambulance authority, having contacted personnel and talked to them, asking for them to support him in nominating himself and voting for himself. And the opinions that I've seen says that should be thrown out as an illegal action because it's in violation of the Sunshine Law in the state. And I'd like the attorney's opinion on that.
Okay. Any other statements and announcements from the commission?
My new address is 3861 Hillsborough Highway, and it is very much in my district. And if anybody here, there has been one person in particular that's called the voter registration, called other commissioners, and has called other people. If they want to know about me, they can come to me because I know more about me than anybody else here.
Okay, I'll entertain a motion. Got a motion to adjourn. All in favor, stand up, please, if you can. I thought it was 4 hours. Really, it's 4 hours and 24 minutes. Yeah, we started at 6, so 4 hours, 24 minutes.